Side.
No, I don't.
When I take a papillate site, please mention it. Now we have the original site.
Okay.
Please.
Any original site mentioning? Listed matter item number 1 for judgment. Kolkata Metro Rail Corporation Limited versus ITD
Sorry.
joint venture.
In view of the above findings, APCOM 381 of 2024 is allowed on contest, thereby setting aside the impugned arbitral award dated August 6, 2023, passed in the arbitration proceeding between the present parties under Section 34. No address to cause urgency.
To be mentioned, item number 2.
No, I am for the petitioner.
I am for the respondent.
I'm for the respondent 3 to 9.
Peculiar situation.
On the
We
last
had-
occasion, talks of mediation, Millard.
Yes,
We
Lord,
were
I just want to clarify, my Lord.
This
We
was-
want
that
to,
was my-
of course, we want to settle. Who doesn't? My Lord, 15 crores we wanted to buy an office space from the Ideal Group, one of the Ideal Group entities, who, my Lord, are reputed to be in very bad financial condition today. All their projects have stopped. Now, my Lord, I'll be very candid with your Lordship. The condition, বাইরের ছবিটা দেখাও. My Lord, it's a half-finished, large office building. I'll just hand up a recent photo.
They are the realtors. They are the realtors, and you want to.
Yes. Yes, I am the purchaser. This is for my office. This is the condition exterior, and this is the condition interior. This, my Lord, is the situation. I've paid 14 crores out of 25, 24.
How many floors?
One floor, but large area. I
Interior.
think it is 21,000 square feet and 27 car parking spaces. What happens, my Lord, if these companies go into insolvency is that, my Lord, all my money is gone. I want to pay the rest of the money. Whenever I know that I have to pay, I will need within 20-25 days, I will make payment. I am even ready to make payment and have conveyance executed in my
What
favor.
will be your position in the pecking order of creditors, Mr.
Not very low. I lose everything unless I do something called reverse insolvency, where all the home buyers go and they may not take over the project and complete it. But even if I have to do that, I'll have to pay the rest of the money. Now, what my learned friend is saying is not totally, my Lord, incorrect today. It's not that he is not genuine. He's not trying to take out my money. There's a financial partner in the project, which I am aware of. That financial partner was contesting the Section 11 and saying that I did not give authority for the sale to you, which is why the matter was pending.
This is Section 11.
Yes, for determination of that question. I am now told that that financial partner is pumping in money into the project for getting areas which were to be allocated to him finished. So maybe, my Lord, I am within that. Maybe I am outside that. What will happen to the rest of the area? Because we are very interested. Otherwise, there's a good chance I'll lose my 14, which I've already given. I don't mind paying 11 and taking it. So, my Lord, I am, my Lord, humbly praying, if your Lordship permits, that we sit together and we discuss these issues and come back next Friday before your Lordship.
This was already sent to mediation. No.
No.
Talks of settlement.
No, we can, my Lord, discuss with the concerned people. It won't happen between my learned friend and me, who, my Lord, are nowhere in the pecking order.
If the goodwill is there, there is no difficulty.
Yes, if his client, if he is there, I'll bring my client also, and if we can discuss.
Let us attempt settlement and come back next.
Because if the building comes up, I'll gladly pay. I have just one condition, that completion certificate, and number 1, number 2, conveyance, I pay the whole money together. If required, I'll even agree to deposits,
Should I put
etc.
it next week or the week after that?
Week after that, then.
I think that will be better, because if there is some other person.
Grateful.
Learned senior counsel appearing for the petitioner
I
submit
think we can work this out.
that there is a fair chance of settlement between the parties in the matter. Full stop. Learned counsel appearing for the respondent number 1 does not oppose such submission. Full stop. Next para. Accordingly, let the matter stand over till November 14, 2025, when it will be listed under the same heading for the purpose of exploring chances of settlement.
Lordship, I'm appearing for respondent 329.
You also agree to this submission.
I have no problem.
Very
No
well.
objection.
Because I'll tell
Counsel
you,
for the respondent number 1 and respondent numbers 3 to 9.
because
এখানে 1 বলো and respondent numbers
I'll be very candid to your lordship. Even if I go to arbitration, the process will be overtaken by a possible insolvency. So I am desperate for a settlement.
understood. Understood.
May it be on the 21st. 14th, I am in some difficulty. I'll have to leave out.
If there is no
Very
difficulty.
well, I have no.
Very well. তাহলে returnable date টা 14th না করে 21st
Lordship.
of November 21. Thank you.
Now there is no insolvency proceeding.
No, I know, and I hope it doesn't come. I hope more than you that it doesn't come.
Yes, obvious.
Genuinely hope to settle.
Very excellent.
Contempt matter, item number 3, Electro Steel Castings Limited.
Now, right?
Lord, IPA for the alleged
Definitely.
contempt.
I appeal for the petition.
পরে ফেলতে ready করে রাখো। What is the nature of the contempt?
My lord,
Either of
It is non-compliance of an order, Lordship, by which the incentives had been directed
Oh,
to me.
that. Yes, Mr. Dattu. what is-
my lord, your lordships, my lord was pleased to, my lord, direct the alleged contemptor to be personally present
Yes.
today, my lord. She is present.
You have preferred an appeal.
My lord, the appeal has been preferred. It's our fault that, my lord, it could not be heard. And finally, my lord, on one day, my lord, we could not respond to the call, my lord. The matter has got dismissed for default. But we have applied for restoration. It has been mentioned also. My lord, the Honorable Division Bench has verbally observed to appear on the 4th of November.
I'll give you an opportunity to show cause to the rule itself. Previously, it was an affidavit in opposition. Before sending you to jail or penalizing you, I have to give you an
The
opportunity. for
rule was issued.
rule was issued.
No,
This is
ওটা
the last
show cause
opportunity
notice দেয়া হবে। ওটা show
because
cause
no
তো দেয়া
show
হয়েছে।
cause was filed to the rule. Before doing taking any
They-
penal measure, Mr. Ali, we have to give them a last opportunity to file a show cause to that.
But
But
I
this will be
subject
last
to correction because I was a late entrant. Possibly, my lord, we have issued used a show cause to the rule.
Then
Possibly, my lord. I am not very sure, my
I
lord.
have to now penalize you.
Yes. But I can only, my lord, make this prayer, my lord. Please have a look to my lord's previous day's order.
Yes, that is.
My lord, the court was under an impression quite rightly that, my lord, we have not taken any steps in the pending
You have
appeal.
in the contempt you have taken as a defense, not as a defense, as a tool to ask for time showing the appeal,
Right.
and then you don't be
But, for my lord, the conscience of the court, to clear the conscience of the court, but I have downloaded, my lord, the case status. Please have a look to the case status. What can I do, my lord? Please have a look, my lord. Please have a look, my lord.
dismiss or default. That is,
No, kindly see how many days, my lord, the matter was taken up.
before being dismissed or default.
Yes.
Oh.
Well, these are for so many days, but at one
are
point of
listed.
time, if your lordship recollects, that I had, my lord, informed the court that I'll personally mention the matter. I mentioned the matter, the division bench was very kind enough, and please take me the third page. Kindly take the right-hand side column. As an upgraded matter, my lord, this has appeared so many times. But unfortunately, my lord, could not be taken up. But the day, my lord, it was called, my lord, my lord, of course,
Dismissal
it's-
for default goes against you, Mr.
Yes,
Dutta.
yes, yes.
What-
But I can't say that if there is a dismissal for default.
Your client will be the scapegoat.
Yes,
The client-
absolutely. Yes,
Client will be
absolutely.
the scapegoat.
But if I may, my lord, only request, my lord, for one opportunity. And
What is the position? It's appearing in some list.
no, my lord, restoration file mentioned on the reopening day, that is last Friday.
I don't know what to do actually. If you have filed a show cause to the rule, I don't have any other option probably. Show cause টা আছে যেখানে রুলের এগেইনস্টে কোনো অপোজিশন
17th of January they filed করেছে।
রুলের এগেইনস্টে তো কোনো অপোজিশন
The affidavit affirmed on 16th January 2025,
yes it is
filed on
there.
17th.
What is the defense taken there, Mr. Dattu? That
Appeal.
Appeal.
then the appeal was still pending.
Yes, yes.
Then it was pending.
My lord, delay condoned, my lord, the appeal got dismissed on, কবে জানো? That's the last.
Mr. Datta, I don't have any option. I'll give you a last chance to comply with the order.
9 September.
And I'll keep it 2 weeks after for passing orders on the rule.
Milord,
I'll dispose of the rule.
could I say this, Milord?
Enough time has been given to you.
No, Milord, I cannot pray for time. I cannot pray for time. Milord, on the last occasion, Milord, Mr. Chakraborty had informed the court about Milord passing of a legislation. My lord has been pleased to Milord record that Milord in the last order. And Milord, your lordship, please have a look.
Cannot go behind the order in contempt jurisdiction.
No. But I would like to, Milord, if not today, Milord, on some other day, I would like to, Milord, refer to one or two orders, Milord, where, Milord, the Supreme Court had considered this kind of a situation
In contempt.
in contempt. And, Milord, prayer was made that passing of a subsequent legislation to do away, but that was a very straightforward case, to do away with a particular order, contempt rule should be issued. Milord, the Supreme Court said that passing of a legislation is the job of the legislature.
That was probably the passing of the legislation itself was taken to be the contempt.
Yes,
Here it is not so.
yes,
Here a legislation has subsequently been passed. I am not saying that the passing of the legislation that's a legislative duty.
yes.
So I am not saying that the legislature is in contempt because you wear
Right.
two hats,
Right.
executive and legislature.
Right.
So as legislature, that passing of that order, I am not saying there is any contempt. But when the order was passed, the legislation was not there first.
Right.
Secondly, even subsequently, legislature may have the power to do so. But Mr. Datta, when was the appeal filed? After the contempt was filed? After
Milord,
the
After contempt.
Then I cannot but take note of that. Contempt was filed in 2024 itself. When was the appeal filed? I don't know.
25 is the
Appeal was filed in 2025. 2025. So after.
Our contempt is of 2024.
Yes.
Milord, one appeal of the WADC is of 2024. State's appeal is subsequent in 25. Now, state's appeal, Milord, has been admitted in the sense that Section 5 was allowed by the division. No,
So I
Section
can
5
only at best grant you time to whatever may be the effect of the subsequent legislation. Mr. Datta, before the passing of the subsequent legislation, when the order was passed, between the order being passed and the subsequent legislation being passed, you were in contempt.
Yes,
So that has not been purged by subsequent legislation.
but I would like to, Milord, bifurcate my argument on two compartments. First one I have already told to the court
Yes.
about the legislation. The second part is, Milord, I would, of course, Milord, again, Milord, saying that, Milord, I cannot come up and say that I will not comply with the court's order. Milord, so far as the second one is concerned, I would like to, Milord, try to, Milord, impress upon the court, Milord, please consider whether it is a willful and deliberate violation or not. Milord, when the court says that you do this, I am bound to do that. Now, if I don't do it, or if I
Yes.
cannot do it, Milord,
But it's the lack of willfulness in it. I mean, it's deliberate and willful. You knew about the order. You are educated people. You are highly educated people. Most probably more educated than me. And there is no scope of your not understanding the
definitely
not you, not you, your clients. There is no scope of your not understanding the order.
no.
So
But
therefore, it's willful and deliberate. And one appeal was the state filed its appeal in 2025. One appeal was filed before that, maybe, but we don't know whether that appeal was also filed before filing of the contempt application. You have to apprise me of that.
Milord,
Also. You can take instruction, Mr. Datta.
Milord, on that, Milord, I
Take instruction on that.
contempt ফাইলের আগে কি WBIDC আচ্ছা স্টেটেরটা তারপরে
First step-
স্টেটেরটা কি রুলের পরে হয়েছে
No, one appeal was filed before the contempt was filed.
yes
My instruction is otherwise,
Give the dates, Ms. Ali.
Lord.
Mere verbal.
এটা কি
আমাদের WBIDC
14th August 24 তো কন্টেম্পটের
We are on the 2024 appeal.
yes,
The filing date, Mr. Chakraborty, you should have the papers of the file. 14th August.
Well, ours is 23rd August. It is few days before.
7 days
So before your contempt. Before the contempt was filed. Naturally, on 14th August, they could not have notice of the contempt application.
Yes.
So at least one part is saved. But now nothing is left. Actually, I can just give you time to comply with the order, Mr. Dotto. I don't have any other option, even if I would like to, because already we have crossed the stage of issuance of a rule and have given you multiple times. Adjournments were given galore. I mean, probably, I mean,
No,
10,
I-
20 occasions maybe.
But in fact, if your lordship recollects, at one point of time, I came and told the court that I will not
Yes,
embarrass
yes, I recollect that,
in
Mr.
court number 16. But again, Milord, to once again embarrass me, Milord, could your lordship?
It's embarrassing for the court also, but
Yes,
Mr.
yes,
Datta,
yes.
because we understand that it's pending before a division bench. If the division bench cannot take up the matter, I mean, but there's a limit to that also,
Right.
because they are suffering.
Milord, give us Milord 2 weeks time. If I can get Milord,
I'll give you 3 weeks time. I'll
Well,
give
rest
that
of-
time to comply with the order. If you can bring a stay order in the meantime, then it's all right. I'm saying in open court, but otherwise I'll pass penal orders on the next occasion, and your client has to be present on that date also, because I'll be passing penal orders. I'll give you 3 weeks time. Today we are on 31st. I'll give you 7th, 14th, 21st.
Milord, may I pray for a reconsideration on the compliance part?
Willful and deliberate.
Yes. Kindly adjourn the matter.
Why is it not willful and deliberate?
Milord, may I say this, Milord? Milord,
You have
When-
preferred an appeal does not mean anything. That
Milord,
appeal, you know it's pending.
yes, I
All
can,
these principles, you know what I'll be saying.
I can comply and prefer an appeal.
Yes,
Pendency of the appeal, I can comply. All are well settled.
yes,
That does not make the appeal infructuous.
right.
Milord,
The violation is deliberate.
Now, kindly, Milord, simply.
And if you say it's advocate's advice, I can.
You can include me as well.
Not you. You are not there at that point of time.
Yes. so, so therefore, Milord, only this prayer.
We love upper caste people to go behind the bars. No, but this will go online and this will be quoted. No,
No,
this was just a joke
no.
for everybody. We don't love anybody to go to jail.
Your lordship's, Milord, this is.
No, I was speaking of Mr. Chakravarti, the
No,
council.
Milord, I quite appreciate, Milord, what I was trying to, Milord, impress upon various other courts, that, Milord, today, time has come for the judiciary to take judicial notice of this social media circulation
Absolutely.
on judges' observation.
My personal opinion is, Mr. Dotto, if you can put it on the website. Although that also there are some restrictions, there should be a restriction, but if you have to put it up, the entire hearing has to be there.
Right,
Entire, from
Right.
beginning to end.
right.
Whatever the public, because the public has a right to know, it's open court. Transparency has to be there. Whatever we are doing in open court, we are subject to scrutiny. But then when the matter is called and when the next matter is called, before that, everything in between
Right,
should go up,
right.
be uploaded. Now, on this, Mr. Dotto,
But
Mr. Dotto,
Milord, kindly permit me to make this prayer. Please take it up after 3 weeks or 2 weeks. But
no, but I'll direct you to comply. Otherwise, I have to record it. I don't have any other option. The learned Advocate General, appearing on behalf of the alleged contemner, submits that despite earnest efforts on the part of the alleged contemner and her counsel, the appeal preferred against the parent order could not be heard out. For sub next para, it is submitted by learned Advocate General that on numerous occasions, the matter was heard in part before the division bench, then taking up the matter. For in support of such contention, learned Advocate General hands up an information slip stroke case details from the official website of this court, which indicates that, indeed, the matter had been heard on several occasions by the concerned division benches. For sub next para, however, fact remains that despite having full knowledge of the subsistence of the order, the order was not complied with, and ultimately the appeal preferred against the parent order got dismissed for default, which was obviously the fault of the appellant stroke alleged contemner. For sub next para, learned Advocate General submits that in the interregnum, a delegated legislation has come up whereby the
no,
effect.
it's a parent legislation.
Oh, sorry. A legislation has come up whereby the effect of the order under contempt has been nullified. For sub next para, learned Advocate General submits that in certain matters, the Honorable Supreme Court took cognizance of the fact that subsequent legislation intended to nullify previous orders of court might not tantamount to contempt. Next para, Learned Advocate General also submits that there was no willfulness or deliberate ingredient in the violation of the order, since an appeal was pending all along. Next para, even taking note of the fact that the fact of a legislation being enacted to nullify previous orders of the court per se may not amount to contempt, the contempt alleged in the present case is not the passing of the legislation, but at least during the period between the parent order being passed and such subsequent legislation having come into force. It cannot be gainsaid that during the said period, the alleged contender was fully aware of the substance of the order and despite the same, did not comply with the same. For the next para, it is well settled that mere pendency of an appeal does not per se operate as stay of the order challenged. Thus, it was well within the comprehension and knowledge of the alleged contender that an order of this court was subsisting. Next para, moreover, the court takes note of the fact that numerous adjournments had been granted on previous occasions on the ground of pendency of the appeal, but the same was ultimately dismissed for default of the appellants. Next para, thus, since a rule has already been issued and cause has been shown in writing thereto, which does not explain away the factum of violation of the order, there would be no option left to the court but to pass penal orders on the rule on the next occasion. Next para, giving due deference to the Learned Advocate General's prayer that a last opportunity may be given for the purpose of enlisting the appeal and obtaining interim orders therein, the matter is adjourned till November 21, 2025, when it will be listed at 10:30. Next para, it is made clear that if during the interregnum, the order under contempt is complied with and or any order of stay is obtained from the appellate court, the court may desist from passing any penal orders subject to consideration on the next occasion. However, otherwise, appropriate penal action shall be taken on the next returnable date, when the alleged contender shall again be personally present in court.
But only, my lord, I did not want to, my lord, break the
No,
flow.
Yes, yes.
My lord, the submission that my lord has been pleased to record that
Yes.
the subsequent legislation nullifies the court's order. Kindly modify that. It doesn't nullify, it takes away the basis of the judgment.
একটা জায়গায় নালিফাইজ কথাটা ইউজ করে কন্ট্রোল ফাইন্ড করে নেবে নালিফাইজ কথাটা কন্ট্রোল ফাইন্ড করে তার জায়গায় হবে your exact expression is takes away the basis of
Remove the basis of the judgment.
ওনার সাবমিশনেই আছে ওটা removes the basis of nullifies এর বদলে removes the basis of এটা ঢুকে যাবে because এটা ওনার সাবমিশন হিসেবে রেকর্ড
And your lordship is pleased to note her presence in court today.
প্রথমেই একদম করে দিন একদম প্রথমে pursuant to previous direction of the court, the alleged contender is present in court today. তারপর যা বললাম করুন।
I'm grateful.
Item number 4, Dalmia Securities Private Limited.
I'll take up original side matters till 3 p.m. today, so no difficulty. Conclude today. No, every day same expression.
I've never asked. Last.
You have made the same expression every time, whatever you submit.
8th August, man, it was the last time.
No, but
Only today, man.
no. Do the matter. No further time. These matters are pending for so long. I want
know,
to get
but-
rid of this single bench thing.
I know, man, but
Because the
I had
division
some
bench is
problem.
now
with that.
getting heavy.
I was. As it is, my lord, I am unnerved.
You are prepared, Mr. Bray. If you, while arguing, you will recall whatever is your.
No, no, I am not on recalling, man. I am prepared.
There's some other matter.
That is why I was a bit.
No ground. Yes.
And I will not lie to the court. It's obvious, my lord. That is my problem, my lord.
No, I have to finish this
And
matter.
other than that, my lord, I am very unnerved.
Why?
What fell from your lordship, my lord,
Which one?
in the last matter?
Why you are also contemplating to?
No, my lord, in the last matter.
Yes. Why are you unnerved?
Because your lordship said,
My learned friend was appearing for the alleged.
Oh, what?
everyone turned to see.
I thought Mr. Chaprote has been. You are there. Very good.
I was very unnerved.
What you cannot do by diet, Mr. Rai, you can do by other methods also.
That not be a method of me.
Diet exercise is not for you. There has to be some other mode of addressing this issue of.
Now, my lord, I had, as a matter of fact, my lord, I had taken your lordship's, my lord, through the entire, my lord, the documents on record. My end, I'm not repeating those documents, my
Please
lord.
don't, because
My
I'll take
endeavor-
written notes from both of you.
Yes, and my lord, my endeavor has been to show to your lordship
Yes.
that there is no violation of natural justice. That was one of their points. From the very beginning, they were aware of the letter which they say they suddenly got from SEBI. I'd shown that letter. It was mentioned in earlier inquiry letters issued by the stock exchange. Then, my lord, I'd shown that they had at every instance had the opportunity to give their documents what they were called upon for. Specific documents have been called upon. They have said that they cannot.
Yes.
Then they have referred to that certain stock disposals have been made at the central board, the NSE. Therefore, that has to be done through that department and things like that. We said that that is your
You
job.
can get the information from.
Why will I get it? It is you who will come and give it to me. Next, my lord, the points which has been taken, my lord. Now I'll be going to that, my lord. Your lordship wanted me to show that there has been dealings of the show cause and the answer given by them in the main order. I'd also placed the main order in the last occasion, my lord. More or less, my lord, showing that yes, good but indifferent, it was placed. Now, on a technical point, my lord, I've taken the point, my lord, which I said that I'll take at the very end, my lord, whether this point can be agitated by way of an application before your lordship, because the original writ petition did not contemplate a challenge to the main order. My learned friends had said that no, it can be done because liberty was granted by the division bench, to which I had said the liberty was that you can rely and deal with this order in due process of law. And you cannot then, because my lord kindly appreciates this on a remand. The remand cannot in itself, my lord, increase the scope of the writ petition. Because the writ petition, my lord, travelled on the ground that the stock exchange had lured, if I may use the word in a colloquial sense, lured by way of an admission, them to do away with their earlier writ petitions and suits which they filed, challenging these. And then we have said that no, we are not going to accept your proposal of a settlement, and we have proceeded. This is what is the case made out in the writ petition. But this is obviously not there in the application. Application is obviously on a higher pedestal manner, taking the points of violation of natural justice, that the persons who had given hearing or who had passed the orders did not have the jurisdiction. A lot of things they include. So therefore, I said that this point, I will take first, let me show on my merits, but on points, I said that this is a point which your lordship will kindly consider.
So 3 points: no violation of natural justice because there were several intimations
Yes,
and
madam.
opportunities. Show cause notice, show cause reply was dealt with,
Yes, my lord.
and this technical point, so-called technical point, that
Yes,
in
madam.
interlocutory, in an application they cannot take this.
Sorry, my lord, I'm sorry.
In an application they cannot take this point,
No.
which is beyond the scope of the main writ petition and the remand order also.
Yes,
in
and
a
when it
sense.
comes now to the application, my lord, I have another point, my lord, that would the writ court come and decide on such complex questions of law, which are not only complex, but to me, my lord,
Complex questions of fact.
sorry, fact, I'm so sorry, my lord. Complex questions of fact. Law and fact, actually, law and fact.
Complex
Because, well,
questions, definitely it should not. It should relegate it to some other authority. If
Because,
it can.
my lord, because yes, there has been a lot of,
Regarding law, yes.
my lord, may I say this much? Kindly, hey, YouTube, whatever.
That's usual, Mr.
First I used to think khate pete means something to do with eating, my lord.
Khate pite, obviously that will be the first thing you will
That's
think.
what I thought.
And I also thought after
Then we realized, no, it is not. So, my lord,
khate pate, it's actually khate pate,
pate.
not pite.
No, it is not pite. But khate pate. Pate means, my lord,
Pate is the Bengali. Khate.
so these are complex questions. As a matter of fact, my lord, I believe, my lord, I was also doing this before, I think before Justice Banerjee.
That's Sanjeev Banerjee?
Yes.
Yes. What?
For some
What were you
reason-
doing?
It's such-
Khate pate?
Yes.
Acha.
For some reason, he wouldn't believe that I don't know all these things. You don't know, Mr. Rai? You don't know 1, 2, and 3. 1, 2, and 3. जानता हूँ ना. They used to take the phone call and at the same time they would press the button or something like that. So 1, 2, 3. So I never knew.
I
all these things.
empathize with you. He didn't believe I did not know so many things also. I'm sad with him. So no difficulty on that. So very.
So, my
So
lord,
you will now elaborate on these points. You have elaborated.
one point.
Just conclude, yes.
We'll not go into these points anymore. This is what I have submitted. I'm not going to make further submissions on this. Maybe on the last point with regard to that, well, the jurisdictional part, your lordship will kindly consider. I know it is something which is not too much to the liking of this court. I know that. But I just wanted to show, that's why I did not vary away from showing the facts and the merits, and then I'll come to this point. Now, my lord, the only next point which I want to show your lordship, my lord, if your lordship remembers, I had also said that this was not only a violation of the SEBI rules, but because the SEBI, that letter, provided that you will take all actions if there is any violation of your code also. And that is what we found. And we said that there is a deviation with regard to the security settlement guarantee fund regulation.
That's a regulation of the RBI or
No, Malad, this
SEBI?
is the stock exchange regulation, Malad.
your stock exchange.
Yes. Malad, your lordship will find that there is a compilation. না 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 হ্যাঁ এটা তো আমার কাছে নেই বের করে দাও এখান থেকে বের করে দাও আমি বের করে দিচ্ছি প্রথমে তুমি চ্যাপ্টারটা দেখাও যে শুরু হচ্ছে তারপর চ্যাপ্টারটা নিয়ে যাবো Yes. এটা দেখি দাও এটা আমি পেজটা পাচ্ছি না তো তোমারটা কথা পেজ 6 এ যাবে এইটা তো 5
Tab 6.
5 দেখাচ্ছে Okay, whatever. And regulations of stock exchange.
9th হলো bylaws and regulations relating to 6th
তোমারটা দেখাতে পেজ নাম্বারটা আমি দেখাতে পারছি না তো ওটা একটু আরেক page 51 if your lordship kindly chapter 18 minute Well, will kindly take 6 minute. Tab 6 if your lordship has got that. Tab 6 minute.
Yes. এই একটা কিছু কাপড় দিয়ে একটা ময়লা ধুলে জমে আছে, একটা কাপড় দিয়ে এখানে ধুলবে, আবার নামাবে তুলবে, সেটা এইগুলো একটু ছিল। এখানটার ফ্ল্যাপ গুলো একটু পরেরটা একটু আর উপরেরটা এখানটা।
Now, my lord, kindly takes and tab 6, my lord, the next paragraph, continuation to chapter 18. Oh, I'm so sorry.
Do some dusting work first. That's right.
I hope that's not attributable to me.
In continuation, this is number.
My lord, this is continuation to chapter 18, the settlement guarantee fund of Calcutta Stock Exchange.
Yes.
And my lord, this is approved by the SEBI, my lord.
And the securities contract.
And it's under the Security Contract Regulation Act. My lord, this talks about, my lord, your lordship will kindly see continuation chapter 18, my lord. Settlement guarantee fund. What is the meaning, my lord? If your lordship kindly see 3, my lord.
Yes.
Means the Calcutta Stock Exchange Settlement Guarantee Fund established and maintained in accordance with the provisions of these bylaws for the purpose of guaranteeing trades and transactions in securities by active member on C-Star system in Calcutta Stock Exchange. It includes the corpus and all other donations, contributions, levies, charges, and income and properties of SGF to guarantee settlement of deals between the members of the exchange. Now, that is the basic structure, my lord, where if someone does not fulfill their obligations, then it's a settlement guarantee fund which is invoked. Overall, my lord, this is the basic structuring of
As the name of the fund suggests.
as it is, my lord. Then, my lord, kindly sees, my lord, kindly has a look, my lord, at 11, my lord, next page, security deposit.
Yes.
Security deposit means a sum of rupees 10 lakhs kept deposit by a member with the exchange or settlement guarantee fund as security as follows. So it provides that every member has to put in a security deposit. But partially, what your lordship sees that the initial writ petition required the refund of such base minimum security deposit. Now, my lord kindly sees 12, that is at page 3, my lord, internal page 3, if your lordship kindly sees. Settlement shall include an auction settlement, but shall not include a bad delivery settlement. Settlement in which a member or defaulter has been declared a defaulter shall have the following meanings. And then, my lord, it decides what is a settlement, if it's a defaulter or not. That has to be decided in view of this settlement guarantee fund. Then, my lord, now, my lord, kindly comes to page 6.
Yes.
Documents to be executed by documents to my 4, my lord, now. Documents to be executed by the member. Within such period as been specified by the defaulter subcommittee, every member and every partner of every member who is carrying on business on the exchange in partnership and shall sign and deliver to the defaulter subcommittee agreements and other writing in such form as may be prescribed by the defaulter subcommittee from time to time with the prior approval of the defaulter subcommittee of the committee. But under the settlement guarantee fund, a committee is set up which enters into agreements with all members so that everyone is bound under the provisions of the settlement guarantee fund. Then, my lord, kindly sees how the fund is composed. My lord, that I do not have to, it is. Now, my lord, kindly sees my lord, page 7. And 7, sir. My lord, first, my lord, kindly comes to the top of that page, my lord, other sources. My lord, this is a part of, my lord, how the fund is composed. If it has to be returned, how it will be returned. That is basically the structuring of the settlement guarantee fund. Other sources. Turnover charges the rate of such and such based on the turnover of the active members collected by the exchange and handed over to the fund as per rules. All other penalties, charges, and other receipts and levies received or levied from time to time by the relevant authority. All incomes arising from the investment of the fund. Such amount, if any, remaining surplus with the exchange on the anchor sale proceeds of a membership card of a member after meeting liabilities to the exchange. So if someone has to leave the membership, my lord, they sell their membership card, but that they will get a refund after meeting liabilities to the exchange, SEBI and other members as per the rule of the exchange. So there has to be a squaring off.
So you have a lien sort of on that security.
Yes. So the security exchange fund has to be first fulfilled. If that has been used, then that becomes a liability vis-a-vis the fund and the stock exchange.
Only the surplus will be returned.
Only the surplus, if any, will be returned.
Paid, actually. Yes.
Then, my lord, kindly sees on that page, my lord, 6. Administration utilization of the fund and the income of the fund. The settlement guarantee fund will be utilized for such purpose of the SGF has been stipulated by the bylaws and regulations subject to such conditions. Be selected for utilization as the relevant authority may prescribe from time to time, which shall entirely include to defray the expense of creation, maintenance, administration, and repayment of the SGF, to meet premium or insurance costs the relevant authority may take from time to time, meet shortfall and deficiencies arising out of the clearing and settlement deals as provided in the bylaws and regulations. To satisfy any loss or liability of the clearing house arising out of clearing and settlement operational deals as provided by the bylaws. To any other purpose, the SGF has been specified by the defaulter subcommittee from time to time. So this forms a part of the administration of the fund. Then, my lord, kindly sees 8 on that page, my lord. Page 8, my lord, Roman 8. And first 7, sorry, my lord. Liability of member unaffected by cessation of membership. Any unsatisfied obligation of member to the fund shall not be discharged otherwise prejudicially affected by the cessation of his membership. The specific case which they are trying to make out in the writ petition. I do not want to continue with the membership. You keep the base value and give me back everything. That was the scope of the writ petition, my lord. Then, my lord, kindly takes 8. Action for failure to pay. Action for failure to pay to fund. The defaulter subcommittee or committee may take such action as it thinks fit and proper against a member who fails to pay any amount to the settlement guarantee fund, including action by way of suspension of the business or membership of the member, fine, declaring him as a defaulter and or expulsion from the membership of the exchange. So the gamut includes whatever penalty is required to be.
That is for non-payment to the fund.
Failure to pay to the fund, my lord. My lord, what happens if the fund is depleted? Then they will have to put in the excess, the liability, my lord, which they accrue. That has to be put into the settlement fund. That's why I read, my lord.
Fund at the outset, they have to some things will be deducted from them and all.
That's a security deposit, my lord.
That's a security deposit.
Yes.
Oh, acha.
There's a security deposit. Now, if it exceeds, my lord, they have to put in the money.
Who fails to pay any amount to the settlement guarantee fund,
Including action.
So what is the liability to pay? What does the whatever?
My lord, 7 talks about an unsatisfied on that page, my lord.
Yes, that
Roman
is,
7. Unsatisfied obligation of member to the fund. And why is this?
what does the obligation arise from?
What it is just before that?
From 5A, this
No, my lord.
sorry, 6.
6, my lord. Administration and utilization of the fund as the income of the fund and the income of the fund. Kindly see C, my lord.
Yes.
To meet shortfall and deficiency arising out of the clearing and settlement of the deals as provided in the bylaws.
Right.
So, my lord, today, if there is a shortfall because of non-payment by my learned client, that is a payment which I am paying through the settlement guarantee fund.
D does not come in here. D.
No, no.
Only C.
In this case, C.
In this case, C.
Now, my lord, kindly sees
Yes.
9, my lord, replacement of refundable contribution. Because they were asking for a refund.
Hmm.
But that can be done only if they put in a proper security again. Kindly sees, my lord, may permit a member to withdraw refundable contribution of his furnished to the fund, other refundable contribution of the same or greater value under nature acceptable to defaulter subcommittee.
What is refundable contribution?
But if there is something in excess
Okay.
and they want the refund, they can put in some other security.
The entire contribution is otherwise refundable if there is no
If there is no
allegation against them or
because
short.
7, my lord, there remains an obligation till it is satisfied with the one, they can get the refundable part.
Very well.
Then, my lord, kindly takes the next.
No,
Yes.
even if there is no allegation against them, no shortfall against somebody, then he can never take back the refundable contribution.
Yes, he can.
But he has to, 9 comes in, there is no rider to that unless otherwise provided for. Defaulters may permit a member to withdraw refundable
Refundable one. What is a refundable contribution? my lord?
after, yes, that is what I am asking.
My lord, kindly takes the next page, my lord.
Yes.
Non-refundable contribution, a member shall not be entitled to receive back any non-refundable contribution on cessation of membership.
If there is no allegation of shortfall, deficiency, any allegation against a member,
Then it will become
then he
refundable.
can get back the entire refundable
Yes,
contribution.
you can.
But 9 prohibits him from doing that. 9 says whenever you can permit a member to withdraw the refundable contribution, even if there is no allegation, this is without any rider. After he has furnished to the fund other refundable contribution,
My lord,
you
this
have to
is
read into this that if he remains a member, if I want
yes,
to
ma'am.
withdraw
Yes, yes.
and there is nothing payable to you from my end,
Yes,
then
then
I can get back the entire.
yes, but this is if he remains as a member, my lord.
Obviously, that has to be read into this.
And yes, that is
So
there.
permit a member, so that's why let us, yes, very well.
That is there, my lord, because your lordship will kindly read it with 7.
Yes,
It talks about cessation of membership.
that is what reading with
So,
7.
my lord, if cessation, when cessation is there, you will not be discharged of your obligations. That is what it gives. Now, let us say there is no cessation. You continue, but you have a right of changing the nature of your contribution if it is allowed by the
Would have been added here that if he continues to be a member of the,
it says may permit a member, my lord. So, my lord,
because you say here may permit a member to withdraw a
refundable
refundable contribution. The moment you say refundable contribution without any further rider to that, that means the entire thing is refundable to him. Unless there is unless he has some liability or shortfall.
May I try and assist your lordship by reading some part of the next page, my lord? I think it might be, my lord.
Clearer.
It might be.
Second bullet point.
Actually,
Yes.
a member first, my lord, non-refundable contribution. That's second bullet. Refund of refundable contributions. The defaulter subcommittee may refund a member's refundable contribution to him upon his ceasing to be a member, provided he satisfies all the conditions of the defaulter subcommittee. Committee may from time to time impose and provide further that either each of the following conditions as clauses 1 to 5 are satisfied and the condition clause 6 is satisfied. Then, my lord, sees 1 and 2. All obligation transaction of members which are outstanding at the time of his ceasing to be a member, which could result in the fund being required to pay any amount, shall have been closed and finally settled.
Good.
So after these fulfilling, if there is something,
Obviously, yes.
now, my lord, the next thing, my lord, kindly comes to 10 at page 10, my lord.
Yes.
And 10 gives the mode of utilization in case of default. So what will happen? How the SGF will be invoked and how the payments will be made. Then my lord kindly sees 11. If a pro rata charge is made against a member's actual contribution or deposit, and as a consequence, the member's remaining contribution and deposit towards the settlement fund is less than his required contribution and deposit, the member shall contribute to a deposit in the settlement fund within such time as relevant authority shall require the deficient amount. So this becomes the obligation. Then my lord kindly comes to 13, next page, my lord. The liability of SGF to pay out towards settlement or transaction in the exchange would arise as soon as the member thereof defaults to meet his liability to the clearing house of the exchange for any transaction in the current and immediately preceding settlement cycle, and will be limited to the amount of default reported by the clearing house. So when the clearing house, if the clearing house declares that there is a payment which has to be made and it is not made, that has to be fulfilled by the settlement guarantee fund. And when it is fulfilled by the settlement guarantee fund, where the earlier clauses get invoked, and then it becomes the requirement of the member to make good that amount. Then my lord kindly sees 18.
Yes.
There are certain limitations of liability of the fund. The liability of SGF would cover all transactions put through C star, the normal course of trading except negotiated deals, cross deals, fraudulent deals, credit advice exchange, bad deliveries. So what against these, if payments have been made, my lord, the fund will not be liable to pay it off.
See, you don't say these are fraudulent deals.
Yes, there are certain negotiated deals which said that they are fraudulent.
Negotiated and fraudulent.
Fraudulent.
So
That
these
is
are
the-
exceptions. Then the SGF, you need not.
No, the liability is not there. But if SGF has paid it, my lord, then that has to
There's
be
no
paid back.
liability. Why does the SGF pay?
I'll point out, my lord. My lord, today, my lord, what is the show cause for? That these are negotiated deals. But prior to that, my lord, in terms of the time period, my lord, settlement guarantee fund is paid off.
See, from the inception, the allegation was these are negotiated deals and fraudulent deals. Why did you pay off at all?
Well, that is, my lord, kindly, it's a T1 cycle, my lord. But kindly see that just before that, I was pointing
Because
out.
the
my lord.
liability arises immediately.
On the cycle, my lord, clearinghouse cycle,
Defaults.
my lord, just sees clause 13
Yes, 13 is what I'm looking at.
in the current and immediately preceding settlement cycle.
But if your liability does not cover these transactions, whoever you paid these off to, you are entitled to a refund from them. Because your liability, it's not covered by your liability.
My lord, I wouldn't have known that unless, my lord, they wouldn't have. But the
Suppose,
action is,
yes, understood. But you cannot shift the liability to them in the sense that you never had the liability in the first place to pay off these deals if they are negotiated and fraudulent deals.
Yes,
But
my lord.
yes, ad hoc basis, you might have paid in terms of 13. Even if you did that, if you paid
my
off,
lord.
you can always come back and show that as
My
per
lord,
18,
I
I have no liability. So whoever I paid it to, they have to give it back to you.
my lord, kindly appreciate.
And they have to
Because
realize that from
I'm
them.
the guarantor. I'm the
but
guarantor.
18 absolves you of that liability
My
in
lord,
the first place.
absolutely, my lord. I am the guarantor.
So
I'm
when you
making
paid
payment.
off the defaults, didn't you know that those were negotiated
No, I did
deals?
not. That is the inquiry all about.
Achha, very good.
That is why I said, my lord, kindly appreciate that the T1 cycle, my lord, that is in 2020, 2001. That's in 2001. After that, we come to know from the SEBI letter that there is something going on. Then we realize.
But then you get you are unjustly enriched because you enriched because you have a right to recover that amount to whoever you paid because you did not have the liability in the first place, and you recover that from them also. You cannot do it both ways.
Malad, this is, Malad, first of all, it's a penalty and a fine.
Hmm.
And the recovery is under this settlement guarantee fund. I was not supposed to pay. I paid because it was projected that it is under the settlement guarantee fund. The projection is that by the member, not by me.
All right.
Malad, how would I know? Let us say, Malad, I proceed on the basis these are proper transactions.
Hmm.
If they are proper transactions, then there is a proceeding. There is a manner in which they have to pay. If they don't pay, then I'll move against them in the regular suit or whatever it is. But here what has happened? I've been made to make payment in respect of specified liabilities not covered under the guarantee.
13 says, Mr. Rai,
13,
before moving on to the next point, 13 says your liability arises immediately on
13.
the defaults.
13, Malad.
30, Roman 30.
13.
Page 11, Roman 30.
Yes, Malad.
Because we are now between 13 and this
Yes,
18.
Malad.
Now 13 says your liability to the liability of the SGF to pay out towards settlement arises as soon as a member thereof defaults to meet his liabilities such and such.
Yes. For
Uh,
any transaction
yes.
in the current
And it
and
will be
immediate preceding settlement cycle.
yes, and it would be limited to the amount of default
Reported by the clearinghouse.
clearinghouse.
The clearinghouse will report that this
Your
much.
liability may arise then and there,
Yes.
but wouldn't you complete an inquiry and then on 18?
No, I cannot, Malad, because with the clearinghouse, that is my agreement. What would happen, Malad? Let us understand, Malad. Let us
But
say,
how do these two work together? I mean, if you don't have a liability, if you ascertain that you don't have a liability after you pay it off,
then the proceeding is started. There is
after the starting of the proceeding, it's you can recover that amount from
yes,
them.
and there is a provision for arbitration.
You can
also.
recover that amount.
Yes. There's a provision for arbitration for this.
But you never had a liability to cover it in the first place.
Malad kindly appreciates today. Malad, let us say whether I have the liability or not. Malad, I am not in a position to understand that because on that C-star system, Malad, they are not supposed to carry out such negotiated deals. That is the finding. That is the finding. Because I am not in control of any of these transactions. Well, kindly appreciates. I've been asking for that.
No, you're not.
They are in control. The allegation is you have set up someone 1, 2, 3. The way they used to do that.
But at the time when you cleared off the dues from
Sorry.
when you cleared off your liability arose under 13, you did not know that these were not put through your sister system.
No, that is what I'm saying.
You had to inquire that.
No, Malad, C-star system is maintained. It's a system. From there, the settlement
Before
guarantee.
you discharging your liability, you were discharging a liability which you don't
clear-
have in the first place.
I only have to discharge what the clearinghouse is telling me. This is under SEBI Regulation Act, Malad. The clearinghouse, Malkanisis, reported by the clearinghouse.
Amount of that's regarding the amount.
Amount of
It
default.
will only be restricted to the amount of default, reported by the clearinghouse. If the clearinghouse, if there's a default of say 1 crore and
Yes,
clearinghouse says only 50 lakh, you are liable up to 50 lakh. We can understand
That there is a default has to be shown by
that
the
is on the
clearinghouse.
quantum of your liability.
Default, Malad, to the clearinghouse by that member.
Yes, but this speaks about the quantum of your liability. It
Malad,
cannot be more than the default reported by the clearinghouse.
Yes, but this also discusses how I have to pay and when I have to pay. It's a trigger mechanism.
Very well.
Because, Malad, even delivery of stocks is on a trigger mechanism, Malad. It's time related.
The clearinghouse is your, it's formed by you. The clearinghouse, it's an independent entity.
Yes.
So you have to pay that amount to the clearinghouse.
Yes, Malad.
But when you come to know that these are not transactions put through your sister system,
The clearinghouse is within the stock exchange.
it's situated within the stock
So
exchange.
it is the stock
Not
exchange.
independent.
No, no, my lord,
something.
my lord,
That was what
Calcutta
I
stock,
was, yes.
correct. Calcutta Stock Exchange.
Yes, there.
My lord has
another
always,
top-
my lord, had the system, my lord, of having, my lord, the exchange where transactions occur
yes.
and my lord, trades are settled, which is the clearing.
Right. That's the nodal sort of.
My lord, the same organization.
Yes.
That bifurcation is what SEBI was insisting on.
Yes. All right.
Malad,
They did not meet. That's why their license went.
But I'll take it from there.
My lord, clause 10, my lord, your lordship will find, page 2, my lord, This is, my lord, clearing house means the department of the exchange or clearing corporation set up by the exchange to administer the process.
Yes.
My lord, I have set it up in terms of the regulation. And today, my lord, what is my learned friend is saying, my lord kindly appreciates what is the allegation that you have carried out transactions with defaulting members. How would the clearing house, my lord, come to a conclusion that this is a proper deal or not a proper deal? Is that the obligation of the clearing house at that point of time? Clearing house will only see that at that cycle, how much money is due and payable by a member. Then, my lord, kindly sees.
But if this was not any of these negotiated deal or did not fall under 18, then also you could recover from this them. This
Yes, because I made a payment through a settlement guarantee fund where I am guaranteeing, my lord.
What would be the meaning of clause 18 then? It would be rendered a toothless clause.
Clause 18, my lord.
18, because irrespective of your liability, then you would have to pay off immediately when the clearinghouse says you have to.
And it kindly appreciates what is this fund.
You are paying off something which you don't have the liability to pay even. The
Malad,
funds don't have
may I
the
just try and explain in my way, which where I have understood, Malad. Though very little I am understanding, but I am trying to assist, Malad. Malad, this is a settlement guarantee fund. What is a settlement guarantee fund? It guarantees each of the members that in the event, Malad, payment is not made or
not a blanket liability of the settlement guarantee
I'll
fund.
come to that, Malad.
The liability is restricted by 18.
I'm coming to that, Malad.
The liability to cover up that
Absolutely.
balance arises only if it is not a negotiated or a fraudulent.
Absolutely, I'm there, Malad. I'm just coming to that. Kindly appreciates, Malad.
Yes.
Malad, then in that event, Malad, I am supposed to cover any liabilities which is covered by this fund.
Unless they fall within 18.
I'll come to that. I'm absolutely, Malad. So I'll have to do it within this fund, and the fund only allows certain numbers of deals, certain deals, not other deals.
So you misuse the funds by paying off to the people. I mean, that could have been the liability of them, the persons who.
It should have been their liability.
So why did you pay off in the first place and now asking?
Because, Malad, that is the C-star system. That is the system. Malad, let us understand, Malad, a guarantor is made to pay off money of a due.
So like a bank guarantee sort of.
Yes. So I will not have the right. I'm asking myself this question. The person who has made dealings which are not covered is going to go scot-free. That is the proposal of the writ petitioner. That cannot be the case, Malad. I have made the payment. Because this is, with humility, I say, Malad, this is not unjust enrichment. I am out of pocket. And
it will be unjust enrichment in the sense
to the
that you are getting
maybe
double payment.
Third party maybe, but where, Malad, I have already alleged that they are all in sync with each other.
No, not third party, because you don't have a liability. You can always recover it from whoever you paid it to.
Malad,
You can say, I don't have the liability. Refund this back to me. This is a negotiated transaction. And
Malad, who has negotiated? If I ask myself this question, Malad, if I come to a conclusion the negotiation was done at the instance of this member, who has intentionally done it?
Not your lookout, because this fund, SGF, does not have the liability to cover negotiated deals.
That is it, Malad. So if I have
But
been
you still covered it.
I have been made to cover. Malad, let us say this way. Let us put
Now you recovered it from them.
Yes. Malad, let
They
us
can always go back and say that I did not have the liability. You also give back the amount to me.
Yes.
From those people to whom you paid.
Well, that is their way of
If you
getting
do
it
that,
back.
you will be doubly paid for the same thing.
How can I do that? I cannot get it back from them.
All right.
We have not, Malad, we have
You can get back because you did not have the liability to cover it. That's what I'm
Yes, Malad. Who will decide whether it's a liability or not under this settlement guarantee fund? Because a third party may not be a party to this. So it's between them and me. If they are aware that these are negotiated deals, falls under 18, then I wouldn't have come up.
No, you had to say to the third parties that look, these are negotiated and fraudulent deeds, so I don't have any liability
wouldn't know
to
at
recover
that-
it from them.
I wouldn't know at that
So
point
there
of
has
time.
to be a
That's my
system by
inquiry.
which you ascertain before paying off.
That is, Matlab,
Liability arises
it's
immediately.
the
You did not pay immediately.
obligation of the member to point it out.
Obligation and actual payment, incidence of payment are different things.
Obligation of the member to point out what is that deal. He's not supposed to put this on the sister system.
I am not saying at any point of time, Mr. Rai, that these persons who are guilty of this negotiated or whatever deals, they will go scot-free. Definitely not. They'll have to pay up. Their liability remains.
I have paid.
But you never had the liability. It was to be
Matlab,
recovered by those third parties from
third
them.
party, yes. So, Matlab, that
You have to have a mechanism in place, Mr. Rai, to ascertain at least prima facie whether those are negotiated deals or went through your system.
nowadays it's gone
before
fully
paying.
computerized, so that's a different thing altogether. But at that point of time, Matlab, things were obviously in the move. Now, the only point which I'm trying to assist your lordship with that, Matlab, the duty of pointing out whether these were negotiated or these were covered under 18 was not mine, but it was theirs. It wouldn't have come into the system then. Once it comes to the system, Matlab, I'm bound by 13. Because that is the cycle for payment. You cannot wait for 10 years and then say that I will make the payment or will not make the payment. Now, Matlab kindly appreciates, if I have made a payment, relying on these, that these are proper deals under this, Matlab, the guarantee fund, then Matlab, who has got the favor? The liability, original liability is that of the borrower, if I may say so, in the context of guarantee, borrowing and
Gratuitous payment you made beyond your liability, and they can come up and say you don't have locus tenure. The people
I'm
who were
very
cheated, they can come up.
if it's a gratuitous liability, then I
You
did
have taken
not-
it up upon yourself to pay them.
then
Or
I
you
can,
did not have
I
liability.
can recover from them. Gratuitous liability, if it's not covered by the contract, I can definitely recover from my reference client. In pure terms of contract, but with humility, then I'll place that one. Because that is the reason, if it's not covered by a contract, gratuitously, if I do anything without the intention of doing it gratuitously, then I can obviously recover.
All right.
But that is
Yes, yes.
there's a specific section. I'll just point that out. It just gives me.
Right, right. It depends on your impression. I mean, if you knew,
Sorry,
you did not know at that point of time it was gratuitous. You thought it was your liability.
that I thought. Today, if they fall on, if they say that, look, you've done it gratuitously, then also have a right.
All right. Yes.
Now, kindly sees, Now, kindly sees, it kindly comes to page 15. 15, that 15 on the bottom of the page.
Yes, yes. 15.
Payment under settlement guarantee fund.
Right.
This gives out the specifics of how the payment has to be made. Within 11 days, when your lordship will see that. Then kindly comes to the next page. Kindly sees B at page 16. Notwithstanding anything stated elsewhere in the rules, bylaws, and regulations, if the defaulter subcommittee has reasons to believe that any transaction is not bona fide, is disallowed under any bylaw related to the default of a member, is connected with payment or repayment of a deposit or loan, then if the default amount involved in the payout or the transaction value or the market value of the concerned transaction referred to the defaulter subcommittee is rupees 50 lakhs or more, the defaulter shall record the reasons for his belief and shall not make payment or deliver security out of the fund in respect of any transaction with the nature referred to this bylaw, unless until the defaulter subcommittee finally determines that the transaction is not a disallowed transaction but shall make payment and deliver security in respect of other transactions. If for any reason a payment is made or securities are delivered in respect of any such transaction, the concerned receiving member shall repay such amount or de-deliver such security to the defaulter subcommittee within 48 hours we require to do so in accordance with the provisions of this bylaw. If the to do so in accordance with the bylaw. Then my lord kindly sees,
What is the meaning of this?
my lord, this
If the
means
default amount involved in the payout of the transaction value or the market value is rupees 50 lakh or more, the defaulters subcommittee shall record
Record
the
the
reasons for
reasons.
disbelief and shall not make payment or deliver the security
yes, my lord, this
out
is
of the
because
fund.
belief is already created then. It's not bona fide if at that point of time it is found that is not bona fide or it is disallowed.
So you have a right to withhold it till you have this prima facie belief or
My
disbelief.
lord, we are coming in the next one, my lord.
Acha,
If for any reason any payment is made,
acha,
so we have made already,
are delivered, the concerned receiving member
shall prepay such amount or redeliver such security to the defaulter subcommittee within 48 hours of being required.
So
to
who
do
is
so.
the receiving member?
My
Not
lord,
them.
here, my lord, here the receiving member will be them because they are receiving the securities. Dalmia is receiving the securities. Huh? My lord, Dalmia has two things to do. One is,
Receiving member is the member who is getting the defaulted amount, to whom you are making the payout.
my lord, receiving, my lord, here the receiving is on two accounts. Receiving of money and or receiving of security.
Payment,
Can you see?
it refers to payment, it's very clear. Any payment,
Any payment is made or securities are delivered.
yes, in respect of
So,
any,
my lord, the receiving is either, my lord, it can be on two grounds only. One will receive the money, the other will receive the security.
yes.
The concerned receiver shall repay such amount or redeliver such security to the defaulter subcommittee within 48 hours when required to do so in accordance with the provisions of the bylaws. So the bylaws provision is safeguarded and there is an obligation that they will repay it back.
But under the first paragraph, if the default amount involved is out of the transaction value, market value, default is rupees such and such, you, the defaulter subcommittee, shall record the reasons for its bill and shall not make payment or deliver securities out of
Yes,
the
ma'am.
fund. This has to be read with the next one. In respect of any transactions which is of a nature referred to in this bylaw
So it is,
as disallowed transaction, unless and until defaulter subcommittee has finally determined that the transaction is not a disallowed transaction, but shall make payment and deliver securities in respect of other transactions.
security.
So if you have any hunch on that,
If I did not have the hunch, then I
don't
would
make that payment immediately.
That's the point, Malad. I did not have the hunch. That's why the inquiry.
You can withhold that. I mean,
If I had the hunch,
very well.
the hunch all started after SEBI issued that letter.
And second one covers it. If for any reason such payment has been made,
Yes, well,
or
that
security
is
are delivered, then the concerned receiving member, the member who is receiving the payment,
payment and or security.
you have made the payout to somebody.
Payment and or security. Today, Malad, if Dalmia is selling the security, then it would be entitled to the payment.
No. The receiver must be, receiving member must be the one who received your payout.
Sorry, Malad.
The receiving member must be the one, the member who received your payout.
Yes, Malad.
So your payout was not given to them, to the persons who suffered.
Yes. Malad, they receive the security. It's a negotiated
These two
deal, Malad.
clauses say that you won't make the payout if there is any hunch of any disbelief,
That
any
is
iota
what
of disbelief.
It is not there at that moment.
Suppose it has been, still it has been paid out.
Yes, Malad.
Then what do? Then
Then,
within
Malad,
48 hours, whoever received those payouts, they have to return to you because you did not have the
concerned
liability.
receiving members.
Receiving member is
repay such
obviously the
amount.
one to whom you made the payout.
Malad, the receiving member again, Malad, one is a payout, another is a
This
security.
relates to the payout in the previous paragraph.
Made,
Directly relates to that.
Malad,
It's a continuation.
any payment is made or securities are delivered. So you can either give back the payment or you can take back the security.
Hmm.
It is not only limited to payment, Malad. That is what Malad, these are two transactions, Malad. One is taking the payment, another is Malad in respect of the security. Malad, this has also Malad been covered. Malad, if it allows me, in the order also, Malad, this has been pointed out how this has been done. But it is page 158, if your lordship kindly sees, volume 2 of the GA1. GA1, মানে তুমি ঘুরে আসবে না বসে থাকবে কেন
Yes, 158.
Kindly see the last paragraph, Malad. I'll come back to this again, Malad, but let me just place this for the time being. Messrs. Dow Jones Investment Consultancy Private Limited was suspended from trading on 8th March 2001. As profile was subsequently activated on the trading terminal on 9th March 2001, mainly for squaring off its outstanding transaction position. Knowing fully well that Messrs. Dow Jones had defaulted in the settlement number such and such, Dalmia had indulged in such collusive and non-bona fide transactions with Dow Jones in settlement number such and such. It may be noted that settlement number 49 started from 2nd March 2001 and ended on 8th March 2001. But this is a T cycle of that settlement cycle. Then, since the outstanding position of Messrs. Dow Jones Consultancy were mainly squared off on 14th March and 15th March at a lower price, the sale rate of Messrs. Dow Jones Limited was calculated on the basis of average price of 14th March and 15th March in the script of HFCL, which came to rupees 186.62 paisa per share. The loss on account of collusive and non-bona fide transaction done with Messrs. Dalmia Limited was calculated in the following manner. So there we found that it is not a bona fide transaction. And then, Malad, the question of proceeding against them.
All right.
And then, Malad, the calculations given, I'll come to that later because I'll place it as a whole, Malad. From page 160 onwards, Malad, your
So,
lordship.
Mr. Rai, is this a case where you did not actually physically make out any make any payout to anybody, but the funds were depleted due to this transaction?
Yes, no, payout is also made. Well, that's another part of it, Malad. I'm only showing this part, Malad, that is not a bona fide transaction. So, Malad, everything was happening under the SG.
That depleted the fund, that you can probably ask for
Yes.
from them.
And other than that, proceedings also are allowed under this settlement guarantee fund, Malad. Why I'm showing this, Malad? My learned friend's case has been that the stock exchange had no authority to initiate such proceedings. I say on the basis of that SEBI letter as well as this settlement guarantee fund, I had the authority. This is my primary requirement for showing this.
This does not permit you to initiate any inquiry as such. What does it?
Well,
It's an internal thing, your assessment.
Sorry, Malad.
Your assessment maybe.
No, Malad, I'll just.
There is no scope of any inquiry or investigation.
I'll just point it out, Malad.
Till now, I have not seen any inquiry or investigation provision.
Yes, Malad.
You have to determine at page 17.
Yes, my lord, with notice to, my lord, the concerned member, he has to be heard. My lord, none of that was done. Nothing. My lord, which is why we had pointed that out, my lord.
What was?
That's why the natural justice.
Yes, no, my lord, no hearing at all.
This then, Malad. Malad, what has been the case made out by the writ petitioner? Violation of natural justice on the grounds.
The very next page it is there. It continues. The one which you were reading, the two paragraphs after that, the very next page. That was placed by Mr. Mukherjee. Defaulter subcommittee shall afford an page 17 of it. Opportunity of hearing to the concerned. That is your.
It was given. At every instance, well, I have shown each and every letter given by them.
Right.
They have received, they have referred to the inspection report. They said, I will not give.
Subcommittee hearing.
I will show the defaulter subcommittee also, Malad. I'm not shying away, Malad. But whatever it is, Malad, at no point of time has this point been taken that there is no defaulter subcommittee. They have been replying. Continuously they have been replying.
Who wrote to them? The defaulter subcommittee.
Malad, the stock exchange. And defaulter subcommittee is a part of the stock exchange.
It's defined.
Malad, kindly sees who's the defaulter subcommittee. Malad, kindly sees 4. Relevant authority. I'm sorry, Malad, it will be page 4 of this settlement guarantee fund. Relevant authority, defaulter subcommittee or the full committee or such other committee or person as the full committee may prescribe from time to time.
No, that page starts with the committee,
Yes, my lord.
whereas the committee we defined.
No, no,
Starts
only
with the
page mentioned.
committee.
Yes, my lord.
The committee shall be entitled to make such regulations as is.
Just give me 1 minute.
That committee decides and forms the default.
It is after that there is also, my lord, the explanation. I'm just trying to find out before that, my lord.
Is referred to as a full committee in 15.
Just give me 1 minute.
Mhm. That will also decide the powers of the defaulter
But
subcommittee.
it is also there before that. But I just point out, my lord,
Uh-huh.
in 14 minutes talks about the committee shall be entitled to make such regulations and
Yes.
meetings of defaulter subcommittee, my lord.
Which committee?
Never instruction, right? There's one
The
instruction.
continuation of chapter 18 might be there somewhere in chapter. Chapter 18 is there before. Chapter 18 must be there, yes.
Instruction.
What does the original chapter 18 be?
Page 30.
Yes, sir.
GI. That GA টা
I জানি তো।
পয়েন্টটা নেওয়া আছে and no hearing was given.
আমি বলেছি যে hearing was given. There is no violation of accuracy, সেটা বলেছি আমি। সেটাই বলেছি যেদিন বলেছি।
Must be there in chapter 18 somewhere.
Yes, my lord.
This has been called out from that. Anyway, there was a defaulter subcommittee.
There is
there.
a defaulter subcommittee, my lord. No dispute about that.
But then the notice has
And
to
the
be
only
given to the,
dispute is whether it was under the stock exchange or not. But I'll just try to take instructions on that.
but the
my lord.
defaulter subcommittee had to afford an opportunity, not the CAC in general.
I appreciate, my lord. But we'll also have to see what has been done over the years, my lord. It's not that they have not received any instructions or they have not accepted the demands of the inquiry committee.
But they've avoided producing those documents.
That is it. And my lord, if there is any dispute, my lord, why will they not go to the arbitration?
And they didn't raise a dispute that there is no default committee in subcommittee in place, or you don't have any locus standi or not.
No. It's only after this order that they made out this case.
All right. Very well. But this committee is in place because there's an appeal contemplated against that also.
Correct.
Page 17.
Yes.
Was there any appeal or was there?
There is, my lord, the order came, they immediately went to the division bench, my lord.
Is there a committee in place? We don't even know that. May file an appeal to the defaulter subcommittee or committee.
Yes, my lord.
Because a member whose transaction has been page 17,
My lord.
defaulter subcommittee shall determine whether or not a transaction is a disallowed transaction within 1 month. So first there has to be a determination by you upon giving notice to them,
Yes, my lord.
and then he can prefer a challenge. A member whose transaction has been finally determined, challenge first before you, or may file an appeal to you yourself,
Yes.
or committee against the decision of the. There has to be a committee against the decision of the defaulter subcommittee.
And also, my lord, there is a provision, my lord.
First defaulter subcommittee, then committee, And then what?
And then, my lord, there is also provision, kindly comes to page 20.
Arbitration you are saying.
Yes.
Very well. So this was just to show that you have the right to investigate and
Yes,
determine.
it is not.
Very
It
well.
is not only limited by the
Right.
Security Regulation Act, my lord, or my lord, the SEBI letter only. Other than that, my lord, the endeavor was to that there is a proper, my lord, procedure laid down. Which also culminates into proceedings which can be challenged into in an arbitration specified for this. And on top of that, my lord, what I want to say is, my lord, be that as it may, they were aware that the proceeding has been initiated in 2004. So what is it that they were trying to contemplate, that they will stand still, not challenge that there is no defaulter subcommittee, the inquiry is not bad or inquiry is bad, and just when the order is passed, then they come and take all these points, in spite of the fact that they have been replying and very well understanding what is the scope of the inquiry.
Right.
Now, my lord, will kindly from that, my lord, compilation, my lord. Tab number, tab 5, my lord. Tab 5. Number. Well, this has been, well, this is basically with regard to the dealings of the stock exchange, my lord.
Mr. I'll just come back in 10 minutes and continue.
In matter, item number 4.
Yes, sir.
My lord, I would beseech your lordship, my lord. My lord, if your lordship allows me, my lord. My lord, if I can get one more day, my lord.
No, 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 no.
Yes,
Sir.
my lord, I'm a bit,
No, no,
my lord, on instructions, my lord, I'm a bit.
no,
That
no,
is why, my lord, I'm submitting, my lord.
no, for that. Let's continue.
My lord, may I just take your lordship back to the scope of the application so that I don't have to answer more than what is there in the
You
application? my lord?
touch your main points and just indicate the points and cite whatever judgments, and you'll put it in your written notes.
No, my lord, I'm because my lord, certain query failed from your lordship, my lord,
Like
with regard to the committee. Then the subcommittee, how it has.
instruction in the meantime, no difficulty because this will not be over today probably.
No, my lord, these are documents which will obviously 2001, my lord. So, my lord, obviously that is why I was only beseeching your lordship. Kindly give me one more day and Friday I will
No, no,
finish.
you
If I
make your
don't finish,
arguments. Mr.
if I don't finish, my lord, you'll kindly, my lord,
No, no, no.
I'll close my arguments. My
You'll
lord.
close your
But I'm
argument.
feeling a bit, my lord,
No, only on that, whether there was a committee or not. So we can deal with it later. You can point out later also. I don't think any point was taken by them contemporaneously. There was no defaulter subcommittee. Was it?
that is what I'm trying to show from their opposition.
If they had
from
taken
their
that point, then you
application.
ought to have been ready on that.
My lord, I'm taking it
And
on
they have
myself,
not.
my lord.
They have not taken
I'm
that point.
taking it on myself, my lord, that yes, I should have been ready
No,
on
sir,
this
it's
point. my
going
lord.
on for so long. Let us complete this.
But I am just saying, my lord, on
Because the other
Friday,
matters, the people will not be ready, Mr. Rai.
on Friday, my lord, I'll complete. I'm
No,
giving
no,
my
no,
word.
no.
my lord.
Please continue. You argue on the other points at least.
Sorry, my lord.
Argue on the other points also. There are other. This is the last point.
This is one more point, my lord.
So you argue there.
I'll argue that.
Only defaulter subcommittee, whether it was there or not, leave that. You can cover that on the next day when they are arguing. Just whether it was there or not.
My lord.
But if there is nothing on record to show that it was there, I won't take any new document now.
Sir.
If nothing is on record to show that defaulter subcommittee was there, I won't take any new document now at this stage. This is at the advanced stage of hearing. You have been hearing for some time.
Therefore, my
So
lord,
I won't permit you to file any new document.
no, my lord, I understand that obviously, but I
You
also
can take instruction on whatever documents are on board.
on that, my lord, not only that, my lord, what I want to just find out, because my lord, the point which I found with the committee, now where did that committee come from? My lord? Because all the regulations are not before your lordship, my lord. Also, I have not gone through that. So that is what I just needed, just some clarification. My lord, I'll complete, my lord. I will
Yes,
not renew my prayer, my lord. I'm grateful, my lord. I'll just complete it.
Yes.
And then, my lord, I'll put whatever is required, my lord, in my notes, my lord, if your lordship allows me, my lord. My lord, let us come back to the application.
Yes. Which volume, Mr.
My lord, application volume 1, my lord.
Yes.
I'll just show the pleadings because I'll confine myself to that only.
Absolutely.
And let me not also, my lord, increase the scope. My lord, because this will go on then, orders will go on,
Exactly.
my lord. Let
Exactly.
me not increase the scope. Let me be also, my lord, bound by the
Their
pleadings. my lord.
challenge is also very limited. I mean,
My lord, I don't know what is the challenge. Whether the writ petition will be a challenge or the GA will be a challenge, my lord.
Yes,
If the
yes,
GA is the challenge, my lord, then that is what I'm trying to show you, lordship, what is the challenge.
right.
Because writ petition has said that it is absolutely not within the whatever my learned friend has argued is beyond the scope of the writ petition. Absolutely beyond the scope. Now, with regard to this, my lord, if your lordship kindly sees, my lord, my learned friends kindly takes, my lord, paragraph page 10, my lord. Very quickly, my lord, go through this, my lord, because this is what I had placed on the earlier occasion, but I think, my lord, I would like to also reset myself with regard to this. My lord, page 10,
Yes.
my lord, last paragraph, sentence, my lord, in the first part of the paragraph. Respondent number 1 in garb of SEBI's letter had undertaken a roving inquiry with the sole intent of harassing the petitioner company with malafide intention, and has now passed the impugned order without following due process in the teeth of settled law in this regard. My lord, I had shown, my lord, in the SEBI letter, I was allowed to proceed under the violations of any of the regulations of the exchange also. So to say that was a roving inquiry,
So you are
if it
heavily
was
relying on the SEBI letter
SEBI,
as well as your own provisions which you just not showed.
SEBI letter also allowed me to proceed, my lord. Let us say there is no SEBI letter. Then also, if there was a violation, I could have.
You have shown both, yes.
The SEBI letter basically opened my eyes. And I got through. And not that it was something not mentioned by SEBI also.
Hmm.
And what is my learned friend trying to say? SEBI has initiated a proceeding and SEBI has said, yes, there's nothing wrong with you. But on the other hand, I've been told to proceed. Malad, these are big things, big things which are beyond our thinking also, Malad.
So legally speaking, no.
Legally, Malad, I'm not too sure what is the
Financially, we can't say.
Financially,
I can't say about you. I can say about myself.
Malad,
I can't take your responsibility. Tomorrow,
I would have
SEBI
loved
will
it
be
if you not
behind you.
sitting.
I've never transacted in stock market even once. So therefore, I am quite competent to deal with these matters because I'll be completely unbiased and uninitiated also. So you are teaching me the law also while you go. This is not the first matter. You have taught me the law, previous matters also. So so that your client is not, shocked
I am
that the judge is hearing of.
really worried about that.
No, I know about this subject, but you have taught me that. The bar has taught me that previously.
Now,
Yes.
see, Malad, paragraph 12.
Yes. 12.
In a matter of record, in the period from 2002 to 2004, the respondent number 1 had asked for documents and information in person of the limited inspection exercise, and that all available and requisite information, clarification documents are provided.
Mr. Rai, are you trying to argue on that point that this is beyond the writ?
Not only that,
Achha.
I'm also trying to show
Yes.
that now you're saying there was no subcommittee, there was
So these are not there in the,
no,
in the
and
application.
they had conceded to it. That is what I wanted to place. I'll place it on the next day, and I'll make a short note and file it before your lordship once they, because I want to show that the committee also has a right. Subcommittee is under, because I was a bit concerned because I wouldn't have been. But since it fell from Mr. Mukherjee, that is why I was a bit concerned. Or else I would have proceeded. That's why I said that I would like to have a look. Because Mr. Mukherjee will obviously not say something which is not aware of. That is what made me a bit wary, my lord. Now, my lord, kindly sees. Inspection process also been concluded and or was not pursued thereafter. Where did they get this from? If that would have been the case, all suits would have failed by now, which are pending for 40-50 years in this court. Now, furthermore, there was never any adverse finding against the petitions even the course of such inspection exercise. I have shown specific letter of 4th March 2004 where there was an adverse finding. We said that you have not discussed all these things. Where are the documents? And they have very plainly and simply said, first they said, we do not have these transactions.
No, at the inspection stage, there need not be any adverse finding also.
No, they say, I had replied back. It's not that it was one-way traffic.
You are only entitled to ask for, the documents and they are to reply to.
They first said that we do not have, to which we again gave, we were not under any obligation to say a second time. Several opportunities
Several letters, yes.
Several opportunities given. Then kindly see 13. This is that SEBI conducting investigation. This is a general investigation I showed you on section 19 of the SEBI Act, my lord. I'd shown that on the last occasion, my lord. Then, my lord, they talk about that SEBI have closed the investigation, therefore you cannot proceed. And there's a clean chit, my lord. I've shown these documents, these are not clean chits. Then kindly comes to my lord 14. Significant, in fact, upon being continuously harassed by the respondent number 1 on one pretext or another. So, my lord, they say it was continuing. Harassment, if harassment, I take it also, that means they were getting repeated letters. It's not that I've been keeping quiet. So now they are saying because they were being harassed, they decided to give up their membership. It's a very easy way to do this, my lord. The petitioners repeatedly called upon respondent to process petition was surrender deregistration of membership. Then they proceed to say that, my lord, kindly see just in the below part of that paragraph 14. Shockingly, respondent number 1, has the lordship got that? Had issued letters openly threatening the petitioner if it would not process the surrender of registration of membership on the refund of excess deposit till such legal cases were withdrawn. A bare perusal of the shows the respondent category stated, this informs that your surrender of membership to be processed after legal case is settled.
What legal cases?
They had challenged this proceeding.
What legal case did you initiate?
Not me, them.
Oh, they were to withdraw. That was your.
We said that you don't have to. We said till it is settled, we cannot do anything. Why may I just point out, my lord? Your lordship has seen cessation of membership does not take away the liabilities.
You have shown the provision.
Yes. So since they had initiated a proceeding, your lordship had put me this question: was there any stay? No, there was no stay. But there was a proceeding. We kept quiet. So we said that till it is settled, we cannot do anything. Well, is that the same to say that they were put at a barrel's end?
Where is this letter? Which paragraph?
I mean, this
Which page?
is
Letter F probably.
30th April 2013, my lord.
Yes.
This is.
Can you just ask your learner to just give the page numbers of these letters? I'll just
I'll
take a
just
note.
give that, my lord. If.
Akshit, he had handed up a list of dates that will have all the page
Yes,
numbers.
Oh, thank
It is there, man. It is there. So I was also trying to find the list.
you. You have given the annexure numbers also.
Yes,
Fantastic. Thank you. Yes, yes, right.
Huh.
That's very helpful. Thank you very much. Yes, Mr. Wrights.
It is there, man. It is there, man. I had also made my submissions relying on this list of things.
Annexure F.
This is page 138, volume 2, GA number 1, my lord.
This is a serial number
This is serial number 31.
31, my lord.
31. The previous ones were of the writ petition, the previous annexures.
Your lordships, wherever the documents are there in the writ petition.
Oh, acha.
given
You
there.
follow the chronology and
They follow
It's
the
there.
chronology. GA1 is the application and WPO is the military petition.
right. Thank you. Yes. Very well.
After legal case is settled.
Right.
Then, my lord, kindly comes. Unable to process, my lord. As well to conduct an alleged investigation, pose the yes, my lord. 15. In these circumstances, the fact that the respondent number 1 has proceeded to conduct an alleged investigation post the filing of the writ petition, which claims was pending, and subsequently pass an order against the petitioner company abundantly displays the malafide of the respondent number 1. But they had withdrawn those writ petitions. It must come to a conclusive ending. Then the respondent number 1's action reeks of institutional malafide and appear to be an afterthought throughout the release prayed for by the petitioner. And this, on this ground alone, the impugned order is liable to be set aside. May I wait, pause here for a moment? So what they are saying is that their reliefs, as they claimed in the writ petition, is being thwarted by this order. That is the case. If that is the case, my lord, kindly appreciates. Let us look at it only from the relief in the writ petition. The relief they are asking for is a refund on the basis of a certain admission made by my learned client. My client, on my client. Now, whether that can be affected by this order. What did I say? I said that your obligations are to be found out. In terms of the SGF, your return is also under the SGF. So it...
You reinitiated all of this after the writ petition?
No. It continued. No reinitiation. But the process had been put into motion. I did not proceed because of the case. I admit to that. I could have proceeded since there was no stay. And the point is, Malad, those proceedings were initiated by them. And then to say that, no, you have not taken any steps in the meantime.
No, they say that after they initiated the writ petition, then you undertook this exercise of investigation or started it after so many years, and this is a malafide sort of thing.
Petitions, Malad, they have withdrawn.
Must be after this order was passed or something.
Malad, this was 9th July 2013.
Oh. July 2013, the writ petition was withdrawn.
The one and the suit also, Malad?
No, without any liberty to sue afresh. Is that withdrawal order anywhere?
that would be, my
Annexure
lord,
in this application
দেখো তো
must be-
annexure F, page 141, volume 2. Page 141, volume 2 টা খোলো।
no.
And
No, the writ petition, this writ petition was pending.
which one? Sorry, my lord.
WPO 305 of 2022.
That was in 2022, my lord.
That was a new writ petition. That please give me the timelines one.
Yes, my lord.
Previous writ petitions were against what? They sought
Well,
for refund.
No, they challenged the proceeding.
Those letters and all harassive thing, etc. That was challenged, not pressed or withdrawn.
Pressed, waited, and then withdrawn.
Withdrawn after what? Something
My lord, they say, my lord, if your lordship kindly sees the list of dates.
withdrawn when?
My lord, kindly see the list of dates.
13.
Yes, 31, 30th April 2013.
All right.
They are saying there are no dues pending. The surrender of membership will be processed after legal cases settled. That's what you have said.
And this fresh writ petition is for?
This fresh petition is for an admission that since I have asked them to withdraw,
What is the relief sought in the writ petition?
my lord, to return,
Return, for return.
return.
That writ petition was disposed of. What about the remand? You said some remand.
My lord, that is before your lordship.
No,
My
before.
lord, may I try and explain?
I'm wanting the timelines.
My lord, yes.
I
My lord,
forgotten the time.
Before this letter of 30th April 2013, my lord, there were writ petitions and suits filed by my learned friend's client. My lord, the writ petition, if your lordship kindly sees serial number 27. In the year 2006, in the my lord, list of dates. In the year 2006, petitioner had filed 2 writ petitions.
For setting aside 2 letters.
Yes. That's the 6th May 2004.
Those letters were issued by you for
Yes.
asking for documents and all.
Yes. Then, my lord, kindly sees in 30th April, on 3rd April.
Yes. No dues was confirmed according to them, you said.
Yes. That is what they say.
You did.
No, I said no dues, that is pursuant to, my lord, subject to the liabilities.
Achha.
Then they say petition by stated along with the proceeding again requested for surrender of membership. So when the surrender of membership came, my lord, the clause 13 came into effect. Secession will not take away the liabilities. So therefore, my lord, we said that we can only do this after the legal case is settled. Then what do they do, my lord? 9th July 2013, 2 writ petitions filed before the Calcutta High Court have been withdrawn.
Oh, the WPO 305 was filed serial 48, challenging the excess security amount which was withheld away.
Yes.
That is the present cause of action.
It's present cause of action. On the ground that there is an admission by your side, since I have withdrawn, you must give me back the money.
Final. So,
And my lord, the no dues which they are talking about, my lord.
the learned single judge said the court is of the view that CAC should take a final call on the investigation.
Yes.
That such finally be taken within a period.
Why was that, my lord? May I just point out, my lord?
Yes.
My lord, if your lordship kindly takes, my lord, in the writ petition, page 25, sorry, page 79, in the writ petition, my lord, WPO.
Page 70.
Well, may I just read it, my lord? I think that would be
No, page 70.
79. They wanted a conduct certificate.
Achha.
There we say it has got no dues. Then we say, however, this should not be considered a guarantee for any liabilities that may arise in the future in course of the business of the said
Future,
company.
that is future.
But the liability is rising in the because the proceeding is
It
continuing.
arose previously.
This is future, as in unless the order is passed, the liability is not fructified.
It's a total recall scenario, like the movie. Anyway, leave it.
And my lord,
Your entire past memory was implanted in your head a few minutes back.
yes, my lord, could be. But whatever,
So very well. But you said these are different
and this is
stories.
saying
Yes.
without prejudice to the rights and contentions of the last sentence, my lord. So this is not a,
In other matters.
yes, my lord, in other matters, this is them, my lord, this is for them. My lord, this cannot be treated as
No,
a,
you don't say that there are no dues.
that is what I'm saying, my lord, it's subject to.
No, you are not.
My lord, it says only in the contact certificate in the first
No,
paragraph.
we
my lord.
would like. Oh, yes, we would like to inform you that as per the records, such and such is an inactive member of the exchange. Oh, it has
dues
no
of the
dues.
exchange as on date.
That's somewhat critical.
My lord, may I just appreciate, my lord, may I try and, my lord, is this an admission or not? My lord, admissions are obviously, my lord, subject to explanations.
Hmm.
And the second paragraph is clear, it's subject to any liability.
That may arise in future course of business.
Because, my lord, the liability,
future course of business.
course of business, because the proceeding is still continuing.
That's not business.
Sorry, my lord,
Proceeding is not business.
it's a part of the business, my lord. Because
Court
I've got-
proceedings.
I'll point out why. I'll
Court
point out.
proceedings is a part of your business.
My lord, the holding of whether there is any dues or liabilities vis-a-vis their accounts, that is a part of the business.
All right.
Because, well, this is, well, how much cryptic are we going to go is what I'm trying to establish here, my lord. There is a proceeding, the SGF regulations provide that even if you cease to be a member, you cannot have your liabilities wiped out. Pending that, they ask for a conduct certificate, to which we said as on date, because they are not transacting anymore. They are not transacting anymore. Till I can hold them that yes, these were negotiated deals or these were not deals covered under the SGF, I cannot say that there's a liability. That is why the inquiry. Now, your lordship, if of the view that the word business may have other meanings, my lord. My lord, first things first, my lord,
No,
business.
business can have only one meaning, business.
My lord, business as in, my lord, what is business? If I say today, my lord,
What is the business of the stock exchange, of any stock exchange?
my lord, to also look into that the transactions are done properly and in terms of the regulations.
Absolutely. Future
that-
transaction. That's it. That is what you say. Future course of business in respect of the said company. Future course of business of the stock exchange in respect of the said company.
Yes, my lord.
True.
So
But
the business
this,
is,
whatever you are now alleging, arose prior to that.
it might have, my lord, that is what I'm saying, my lord, kindly. It might, my lord, let us say today, the stock exchange finds that there is a due. Before their cessation, my lord, even after their cessation, the stock exchange, the regulation provides that yes, I can ask for this. Then, my lord, would it be a business or it would be a, my lord, I don't know, collection of fine or compensation, but it is a transaction under the settlement guarantee fund. That is what, because, my lord, saying that it is a complete, my lord, admission, my lord, that your lordship will kindly try and
Not say.
no, your lordship, because the standard, my lord, judgments are also,
No,
my lord, that I can
No,
explain.
we were distracting ourselves. So then this WPO was filed.
Fine.
This WPO was filed challenging that your withholding of that amount,
Yes.
security.
Yes.
So there the court, the learned single judge held, no, you proceed with your investigation, conclude it within a
Yes.
limited period. That was challenged.
That was not challenged, my lord. I'll point.
That was not challenged.
बोलते थे. My lord, what was challenged was the order of the learned single judge. The order of the learned single judge was
That is what we are speaking of. That was
No,
not
I
challenged
thought,
means
I thought the recent order, my lord.
WPO 305, the learned single judge held.
That order was challenged.
That order was challenged.
Sorry, I thought of the recent
No,
order.
no.
So, my lord, that order was challenged. When
That
that
order
order was challenged, my lord, it was shown that this recent order has been already passed. To which one of the division bench passes that order, granting liberty?
No, that order was passed at an interlocutory stage of the WPO. Finally
Yes,
decided.
yes.
Yes, disposed of. But the Honorable Division Bench says that is item 60.
Liberty.
Since 45 days period fixed by the Honorable Single Judge has expired, therefore final decision, if any, be taken meanwhile, can also be placed challenge before the learned single judge. This is what gave rise to this problem. You say by way of a separate writ petition, then that's too technical. By a separate thing, is it?
No, my lord, I was only.
We can direct them to put in the additional court fees for a writ.
I'm not on that, my lord. My lord, we are in a GA application. My lord,
This is a continuation of the same transaction,
is it?
and the division bench also constitute to be so.
No, division bench only.
The
said that
division
grant
bench
will-
says you can approach the same learned single judge, the learned single judge, not the appropriate bench, or by way of a separate writ petition. Since division bench says 45 days has been given by the learned single judge closed the chapter, said no, I'm not interfering. You go and complete the investigation, whatever course it takes. I mean, I'm not commenting on that.
Yes.
Division bench says 45 days period has elapsed, I'm extending it, and he'll have the liberty to challenge the outcome thereof before the learned single judge.
My lord,
So therefore, they have challenged before the learned single judge by way of a GA instead of a WPO. We can rectify that by asking them to put in the additional court fees for a writ petition. That is a very technical objection. The outcome has finally been challenged. This is the first adjudication on merits actually on these entire thing. Because in your order it has everything has merged here. Your previous letters, everything. Whatever letters you have given to them, they are non-production of
that is what I was
documents.
trying to submit, my lord. That their writ petition and the scope of the writ petition was not dependent on this order.
How could it be? Retrospectively, it could not. I mean, rather prospectively, it could not be. They could not have anticipated this order. But when it went up to
Even
the
if
appellate
this order
court,
was there, my lord, they couldn't have been prevented from making that application.
if this order was there, they could have challenged. But this order was not there when was it already passed when the writ petition was? Could not have been, because the division bench itself directed complete it. And final outcome, you can challenge before the learned single judge. So they have done just that.
The final decision, if any, taken in the meanwhile,
Yes,
can be also placed, stroke challenged with the learned single judge.
they have done that.
Place they have challenged before the learned single judge, there is what I am trying to say. That whether it's covered or not. Now, I am not taking that point at this
Need
point.
not be covered by the writ petition. The division bench permits that. Division bench permits that. It can be challenged before the learned single judge. The learned single judge refers to the writ court which took up the matter against which the appeal was preferred. The learned single judge. Not with the liberty to them as we usually grant. We grant you liberty to challenge the final outcome in appropriate proceedings or something like that. They have come back before the learned single judge. Unfortunately, it's a different learned single judge because it was assigned. But all the same, they come to the same court, the writ court.
Then, my lord, the
There's
question is,
not much in that objection of yours.
no, my lord, I am trying to only find out what is the question. Today, if there is the writ petition is only on the basis of that admission, that does not apply. Because I have shown from the documents itself that first of all, they do not even affirm it as true to their knowledge. And also, my lord, and last question, please this, my lord, so I'm not making the same submission. And next is, my lord, your lordship will also see that there is nothing on record to show that it was an admission that yes, you are entitled to a clean sheet and you get an.
No, that you are entitled to argue.
And
Yes.
that we have.
You are entitled to argue everything,
No,
whatever was challenged.
That is why I'm submitting, my lord.
Absolutely.
Today, if I have the main writ petition before your lordship, my lord, today the writ petition is there. I am saying these are the points which have been taken. None of them can be looked into. Why? Because it is contradictory to their own submissions. I am not saying anything. They have said that I have lured them. It is not so. It is your action. There is no admission that he shall give it back to you. Now, when this order comes up, that there is already a proceeding, then they come up to the court and say, look, they have passed an order. Yes, they have passed an order. You want to challenge it, challenge it. I don't have a problem. But the challenge, your lordship has to consider both the challenges. Can they be taken up together? That is what I'm on. The division bench might have granted, my lord.
Which two challenges can?
One is the challenge when the main writ petition relief.
Main writ petition was that you could not withhold that security. That has become subject to this final outcome. Now you have a right under this final order to withhold that. If this final order is sustained, if I do not interfere with this final
Under
order,
the cause of action which was in the main writ petition,
that has merged in this final cause of
but the
action.
cause of action was only on admission.
What admission?
That I have admitted that if they withdraw, they will get the money.
You say they're trying to reopen the causes of action also.
Obviously,
The grounds taken,
yes.
which were available at
Today,
that point of time.
let us understand, madam. Today here they are taking the point of the notice not being correct.
They did not take these points in the writ.
That writ petition,
Did not take.
that writ petition withdrawn.
No. In this present WPO.
They couldn't have.
All right.
That is why I want that, madam.
Mhm.
Now, since it's fallen from your lordship, madam, I'm taking it head on, madam. Let us see what case has been made and whether they can take these points in view of the writ petition have been filed and the pleadings contained in the writ petition. I'm not saying that Malad will not take up this GA application, but what I'm saying is Malad will kindly consider whether they are at loggerheads with each other.
Who?
The main writ petition pleadings vis-a-vis what they're saying in this GA application. That
So
is what
you
it is.
say that point cannot be reopened by them now after having withdrawn the previous writ petitions, that those letters were issued by you subsequently could not have been harassive and all this, they cannot.
They cannot.
Because those previous writ petitions were withdrawn.
For
Right.
which they are holding me liable.
That's a valid argument.
That is what I will make.
That's a very arguable point, yes.
Then Malad kindly sees, and I was just placing their application with just the points, Malad. Malad kindly comes back.
Yes.
Para 15, Malad, that is what I was placing.
Para 15,
Page
yes.
13. Application, Malad.
Yes, application. 15. Para
Malad.
15. You haven't started 15 yet? What? Don't go with Mr. Mukherjee. You continue.
No, I'm not going anywhere.
I said don't go with Mr. Chatterjee.
Go.
That's a Bengali expression. You go in the microphone that was coming. So
Oh.
whatever that means.
Malad 15. In these circumstances, the fact that the respondent has proceeded to conduct an alleged investigation post the filing of the writ petition, which it claims was pending, and subsequently pass an order against the petition
Don't
company.
give too much passion into it. You will conclude today. Don't put too much passion into this so that it takes longer.
No.
Be very specific. Yes.
No, I'm just showing.
Don't put passion into their arguments.
No, Malad, I'm only trying to show, Malad, that what
I've seen up to which hand.
which I have to meet. That's it. And kindly sees risks of institutional malafides. I have shown that.
Institutional malafide. Yes.
The reopening of even an inspection process that stood concluded.
Biased, unfair, arbitrary.
Where is it reopening?
Which hunt?
I'm asking myself this question. What reopening are you talking about?
Very well.
You have said that it was set. I said that unless it's settled, I cannot. You have withdrawn. By withdrawing, are you saying that a decree has been passed or an order has been passed? I'm asking myself this question.
This reopening happened before the previous writ petitions were filed. And those who were challenging the writ petitions, they withdrew.
Yes.
So you say now they cannot take this point,
Yes.
resile and take this point.
Yes, just because
I've
order has
understood.
been passed.
Yes.
Now, Malad, then they're saying, Malad, kindly see page 14, just in the middle. The respondent did not carry out any further inspection since 2004. On account thereof, it is clear that such action is the teeth of settled law that in the matter which states that actions by regulators of the Indian securities market have to be taken within a reasonable time frame. There was no occasion for the respondent want to reopen the issues of inspection, pass an order 18 years after an inspection exercise was initiated. The petitioners have suffered incalculable loss and damages, including financial and loss of reputation, goodwill, and illegal witch hunt. Malad, with these losses, Malad, if that is the ground for writ petition for this reason or to go, Malad, I don't think that has been quantified also, and how that loss is there, that is also not there. Then, Malad, 17. In the meanwhile, a final argument in the appeal proceeding before APO were concluded by both sides on March 14. Orders were reserved by the Honorable. The appeal was allowed by a judgment in order of 29, passed by the division bench. And then, Malad, next page 15. They refer to that paragraph, Malad. I'm not relying on that. Kindly comes to 16, page 16. Just on the top of that, Malad, during the hearing that any further proceeding, the alleged investigation was being conducted in this regard. The petitioner's advocate also issued a written representation of 15th March 2022, respondent number 1 indicates placing on record the unjust, wrongful, and arbitrary action of the respondent number 1 and called on the respondent number to cease and desist from continuing with any proceedings or allegedly pending inspection investigation against the petitioners, where the single bench had by that time directed that you proceed. A copy of the written representation is marked as Annexure H. Petitioner reasonably expected that the respondent number 1 would not proceed to take any adverse and/or coercive steps, since the appeal was pending final adjudication, and any such steps taken would be in derogation of the appeal proceedings. Further pointed out that the board or respondent was not validly constituted, and therefore were not in a position to pass the order. Now, this is in 2022 that they are now coming and saying that the board was not in a position to pass the order. The proceeding has been initiated in 2004. The public interest directors, well, this is the next point. Public interest directors, while fully being aware of this infirmity, have consciously chosen to pass such order. Then, so they have challenged the public interest directors' action. Again, that is now that they are doing this. Then, the question of whether it was passed on the 15th or it was not passed on the 15th, that has accrued, 20 and 21, and the case which they are making out at page 17,
You've antedated the order.
Antedated the order. I do not know what is the ultimate what
Gain.
I do not know, because antedating vis-a-vis an order passed by a single judge of a timeline, I suppose. That is what is being proposed here, as if the impugned order has been passed within the time limit of 45 days.
They have not left any stone unthrown.
Well, this is the last dice, I believe.
Anyway, that allegation.
They can always take that.
Yes.
And obviously, my lords will also consider whether that timeline would be a mandatory timeline.
Even selecting their worst pleadings and
I'm reading each and every
peripheral pleadings.
I'm no, my lord.
Trying to bypass the main things.
My lord, I have read each and every pleading, my lord.
Please don't do that.
I have, because I knew that this might fall from your lordship. And if not from your lordship,
Taking their worst possible arguments.
My learned friend would have definitely said so. Then, my lord, kindly sees. No, because my learned friend said, my lord, that they have taken the point of that the committee not being in a position.
Yes, that you have already. That is there in at page 17.
But I am saying the timeline kindly appreciates.
Page 16, that board was not validly constituted. That is taken for the first time.
That's for the first time it is taken.
Taken note of. Yes.
Kindly sees 18, my lord, page 18.
Yes. Show me something interesting. If you have to read the interpreting, show the interesting portion.
What am I showing your lordship? If I may ask myself, when I'm only showing the last pleading, that is the grounds, because they don't have grounds here. So I'm only showing the last of the pleadings, every paragraph, my lord. Kindly sees, my lord.
All right.
My lord, page 18. On this ground, my lord, I'm only placing the ground, my lord. I cannot make it shorter than this. And on this
placing all the grounds, you can definitely make it much shorter than this. Who places the entire order grounds? Even the writ petitioner does not place his entire grounds.
Saying, kindly appreciates here. I am saying these grounds were not available. That's why I'm showing that what are the grounds that subsequently.
Tell me what are the grounds. You need not read out. You say I accept that they have taken these points. If you say that they have taken these points, I'll accept that they have taken these points.
But yes, but how they have taken, kindly.
Questions propounded by Supreme Court judgments pronounced, so I place these things.
No, subject matter pertains to year 2002 to 2004. And there is a gross and unjustifiable delay which precludes the respondent one from passing such orders.
That they've repeatedly been saying, yes.
Without aid of the express direction of the Honorable Single Judge. There's a direction by the Honorable Single Judge itself.
So without aid means they admit that with the aid you can do it. That order is there.
Yes.
The division bench affirmed that part.
That
So no difficulty. It is a bad ground. Leave it.
all right, that is what I'm trying to find out which is the good ground.
Best ground is that your no dues.
That I think, Malad, is Malad, I would like to. Then I would say, Malad, that the judgment's galore which says, Malad, that no dues may not be contemplated as a admission, Malad. Well, kindly then sees Malad 23.
Page 23.
No, paragraph 23 and page 18, Malad.
Huh.
You've seen your lordship, just for the first part, show cause has to be issued to person against whom such action is intended to be taken, which clearly defines the charges against such person and also the contemplated action against them. But there was no case of any show cause. I had shown your lordship with an inquiry which was being made. And then, my lord, they got that letter where they said that we will proceed in a hearing.
As per your these regulations, you have to give them a hearing.
My lord, yes, that was given. That was also given.
The notice of hearing is their meaning to be a show cause.
That is what they're saying. But initially they said the 2004 letter is not a show cause. Is a show cause. It wasn't
The
a show
documents you were asking for
cause.
documents. Very well.
Then, my lord, kindly sees that inordinate delay, my lord, they've said. And, my lord, the delay is what they've been continually
They
saying.
are saying that you actually did not start any investigation as such by a proper show cause and giving them hearing and all these things. This you did not. You went on asking for documents. There was no investigation. They were not aware that an investigation was going on. If they knew that, then their defense would be different
No,
before
they
you.
were aware of
That is the tenor of their argument.
I've shown documents that they were aware that an inspection investigation.
I've got the tenor of their pleadings. The tenor of the
the
pleadings in
tenor of
this
the
paragraph
pleadings,
says that there was no proper investigation at all with a show cause notice specifying the charges and all these things, which have to be there in an investigation. That's their
Yes.
case, apparently.
That-
You just sought for documents, went on and on
I-
asking for documents. Suddenly, you pass this order. That is apparently what is
My lord,
sought to be.
that is what they're saying. My
You
lord.
dispel that.
My lord, I have shown all documents. I've shown all the
That
letters.
those letters were given, hearing was given to him.
Yes, they've been called upon for last also they were called for hearing.
Let us see that later where you called upon them to for, the notice of hearing actually. That you have formulated that these are the allegations against you. Anywhere you have formulated, Mr. Rai, show me that letter. Because they have to know what they're dealing with. If it has to be a proper notice of hearing. The court has to be satisfied on that because they have taken this point specifically. Even if you don't write the word investigation in so many letters, you have to indicate that these are the allegations against you. You have to meet these allegations.
Malad, may I place each of the letters, Malad? I need to place these, Malad, because it will culminate into the. I had placed it earlier, though.
No, show me the hearing
yes,
notice of hearing letter, last one.
Last hearing letter is of 2022.
Where is that?
And that is the one against which they have given that letter that we cannot. It's a malafide action, Malad. I'll just show that, Malad.
By the time the matter came up to this court, the writ petition, you had already started that process of investigation. Not started. Because the division bench, the learned single judge held that you have started investigation or something like that.
Yes.
Learned single judge's order was that on that premise, the court is of the view that the CAC should take a final call on the investigation that they claim is still pending against the petitioner without prejudice to the rights and conditions. So you have to show me at least one or two letters, I mean, from where I can gather, the court can gather that yes, you put out the allegations before them and you have to meet these allegations. Whether defalcation or these transactions of which are not bona fide or notice of hearing, whatever.
Malad.
There has to be a notice of hearing under your regulations.
my lord, first thing, my lord, and kindly gives you a moment, my lord.
Yes, 24 hours notice this.
EG টা কোথায়? 7 February 2000 কোথায়?
Your regulation says that you have to give him a 24 hours written notice before finally determining whether the transaction is a disallowed transaction. Afford opportunity and all. Not less than 24 hours notice.
Yes.
Where is that notice?
Targetটা দেখো না। মানে the letters are from page 51 onwards, my lord,
Of the GA or the main writ?
of the GA, my lord. My lord is wanting the one where they have sought for, my lord, the oral hearing or was the hearing to be given.
No, your letter said stating that these are the allegations against you. Do you mean to say, Mr. Rai, that all the string of letters, in all those you have indicated the
Yes,
conspicuous of this
yes.
inquiry?
And there has been replies. Well, that is why I wanted to show all the documents then, because I had already shown these. My lord,
So
these
those letters should be taken, constitute cumulatively.
has to be, my lord. That is what I'm trying to say, my lord.
All right.
Because, my lord, I had shown that there was return of letters saying that you have not given this. This is how this has been done. This is why we are saying that you have
They were in the know of the scope of the inquiry.
wrong, my lord. These are, my lord, prejudicial. It has to be prejudicial.
Yes.
Today it is not a
Has to be
simple natural
prejudicial.
justice test, my lord. It's
No.
prejudicial.
Prejudicial has to be there.
Well, just coming up today and saying that is what I'm trying to submit, my lord. But I'll give that, my lord, I'll give that gist together, my lord, or else it will take the entire day again.
Give me the page numbers in your written notes of arguments, and you just can indicate page 51 onwards these letters, basically.
Yes, yes. 50, no more than that. Well, they're further more. I'll give them all in one bunch, my lord, according to what has fallen from your lordship, my lord, to show that they had the know-how and notice was given and they would be given a hearing.
So they fail on the prejudice test also.
And there's no pleading to that effect. The only pleading is, my lord, the loss of financial loss of that loss and damages.
No pleading of prejudice regarding non-service of notice.
And the only prejudice which they've pleaded is loss and damages.
All right.
Without any particular that shown that, my lord, so I'm not again repeating that. Now, my lord, there are two more points. My lord, one is, my lord, with regard to, my lord, they've taken a point, but Mr. Mukherjee has taken this point as to the composition of the governing body, my lord. We did not have the number of directors required. My lord, I'll try and assist your lordship, my lord. এটা কোথায় কতগুলো বার করো এইভাবে করে মামলা করে খুব বিপদ my lord, with regard to, my lord, regulation 23
Hmm.
of the, my lord, Stock Exchange and Clearing Corporations Regulation 2018.
Which flap? Tag?
My lord, that would be tab, uh, tab 4. Tab 4,
Hmm.
Regulation 23.
Yes. I've got it. Page 23.
তো তোমরা ওটা বলে কিছু মানে this talks about the governing body of every recognized stock exchange shall consider the categories of directors. My lord, at the time, my lord, when this order was passed, my lord, on 15th March 2022, my lord, there were 3 members. All were public interest directors. That has been admitted also by my learned friends, client in their pleading also, that the public interest directors did not oppose, if your lordship remembers, my lord, that the pleading was there. My lord, as per regulation 23(4), my lord, the SCCC managing director shall be included in the category of non-independent directors in stock exchange.
Regulation 4.
My lord, this is
23(4).
23(4).
24 says the managing director shall be included in the category.
of shareholder directors.
Yes.
Now, my lord, it is
So MD was a part of the board.
yes, sir. There's a regulation. My lord, there is already, my lord, my lord, an exemption from appointment of any managing director or chief executive officer who is a non-independent director by the SEBI to the Calcutta Stock Exchange. My lord, that is of 17th September 2019. My lord,
Now, how many members were there of the board, or who had they? What was the composition at that point of time?
three members,
3 members. One was the MD, the other
public interest directors.
both. So you say A and C category of 23(1).
All 3 public interest directors.
So therefore 23(1) is not complied with.
Not required because of, my lord, notification by SEBI. But I just placed that after, my lord, 2 p.m. my lord, because I find, my lord, the document has not been photocopied, my lord.
Sufficient number of photocopies will be required because they will also
I know,
also.
my lord. But for that, if I can come back on the next day.
No.
Huh? No, affidavit is a part of the record. No, affidavit is not there. In the affidavit, I'm not stated.
Obviously, I'm not. Same because it's pointing.
And then many things have also not been said in many affidavits. Whatever it is, my lord. This is on a point, my lord. These are notifications of SEBI, my lord. So obviously, my lord, with humility, I say, my lord, these can be looked
What does that notification say? You have a copy, you can read out. Or you don't have a copy also. You'll have to
I have seen it, my lord.
download it from the website then.
I have seen, my lord, it is with them, my lord, obviously in their office, my lord, I believe.
What does that say?
It only says
Managing director.
the managing director shall be included in the category of non-independent director in stock exchange.
So how does that help?
And CSC is exempted from appointment of any managing director and chief executive officer. So Calcutta Stock Exchange has not been required to appoint any managing director per se.
So who will act as the managing director?
Well,
There won't be any managing director.
Not required. That is the SEBI circular. That is what I want to do. Kindly keeps it after 2 o'clock. I'll place it.
Very well. Okay.
So this would be the only thing. No.
Oh, you'll place something else? Yes. Yes. Dekho na, ekটু পরে. Yes. Continue. You place that later on, Mr.
Yes, I'll just place
continue
that,
with the other things.
I'll only place judgments which have been relied upon by my learned
You can
friend.
start that, yes.
এগুলো কি আগের দিন আমরা দেখিয়ে দিয়েছিলাম? Listed question of fact. দেখিয়েছি? আমরা দেখাবো। তো
But then shareholder directors would be necessary even if there is no managing director. 3 public interest directors. A is shareholder director. There had to be a shareholder director then. A, B, and C. A says
include, well, it's inclusive definition. Shall include shareholder directors, public interest, and managing directors.
so. These 3 have to be there. Managing director, suppose says he does not have one. At least the other 2 had to be there. Public interest directors were admittedly there.
This is the governing board, my lord, of the stock exchange.
Huh.
There they must have a shareholder director, public interest director, and managing director. Now the managing director has been exempted.
So what about shareholder director?
My lord, what my learned friends are saying, my lord,
Did you have a shareholder director there also? All 3 were public interest directors. These are shown as different categories here.
now my lord, may I just place the regulation, my lord, kindly.
Yes.
Subject to the prior approval of the board, the chairperson shall be elected by the governing body from amongst the public interest directors. The number of public interest directors shall not be less than the number of shareholder directors on the governing board of a recognized stock exchange and recognized clearing corporation. So the number has to be more or equal. Public interest directors or shareholder directors. The managing director shall be included in the category of shareholder directors. Any employee of a recognized clearing corporation may be appointed on the governing board in addition to the managing director, and such director shall be deemed to be a shareholder director. So, my lord, this deems
Public interest director in subclass 3 even has been distinguished from shareholder directors. The
Yes.
public interest directors cannot be shareholder directors.
Kindly takes 5, my lord.
Yes.
Any employee of a recognized stock exchange or recognized clearing corporation may be appointed on the governing board in addition to the managing director, and such director shall be deemed to be a shareholder director. So any employee would also be deemed to be a shareholder director.
Yes. Did you have one on the board? You had only public interest directors. How does that make a difference? Both 1A,
Then my lord,
both 1 and 3 distinguish between public interest directors and shareholder.
shareholder directors.
So you had to have both at least, even if you did not have a managing director.
My lord,
You did not have. Of course, you did not have.
my lord, kindly sees, my lord, from 10 onwards, my lord.
Yes.
The voting on a resolution of the meeting of the governed,
That's 11.
the number of public interest directors shall not be less than the
Same.
number of shareholder directors to constitute the quorum for the meeting of the governing board.
So they have been admitted to be separate entities everywhere.
Yes.
Public interest directors and shareholder
Yes,
directors. You had to have both in your board as per 23(1).
My lord, for the passing of resolution is not required. Kindly sees 11, my lord.
The voting on a resolution?
In the meeting of the governing board shall be valid only when 10. Number of public shall not be less than the number of shareholders to constitute the quorum. The voting on a resolution in the meeting of the governing board shall be valid only when the number of public interests have cast their vote on such resolution equal to more than the number of shareholder directors who have cast their vote on such resolution. The casting vote in the meeting of the governing board of the recognized stock exchange or recognized clearing corporation shall be with the chairperson, and that is it. So, my lord, the governing board can pass resolutions on the basis of the public interest directors as a whole, because
provided it has a quorum.
Yes, it will have
quorum has to have public interest directors and shareholder directors. PID won't be less than SD.
The number of public interests shall not be less than the number of shareholder directors. It does not say that the quorum will not be there if there is only the public interest directors.
That would be an absurd interpretation, because otherwise the necessity of shareholder directors is effaced. It could have been only public interest directors.
And that is why, my lord, your lordship will find that the shareholder director has made an inclusive definition with employees also.
Employee is something else than public interest director.
That is why, my lord, it has been made as a shareholder director.
Shareholder director and public interest directors has been distinguished throughout Rule 23. Throughout. And it says board has to have shareholder directors and public interest directors apart from managing director. Even if you are exempt from managing director, it had to have shareholder directors and public interest directors.
Well, let me come back after 2 minutes. I'll show
Yes,
that.
yes, we'll continue with this.
It is good. আর কদিনই
Continue, madam, item number 4.
No, no. Photograph no? একটু এটা কি এ করা যায়নি? People করা কোথায় জানি? Hello, স্যারকে দাও। May I, sorry.
Yes.
May I just point out the resolution which I was referring to, passed by the SEBI, this is the exemption of September 17, 2019. This is the exemption from appointing any new MD, managing director, on the board, because we did not require a managing director. Exemption was sought for, that was given, and it's still continuing.
So you did not have an MD then?
We were exempted from taking an MD.
No, new MD. Old MD was there.
Gone, after that we did not appoint. I have the covering letter also why we sought for an exemption.
Yes, yes, yes.
And that will also serve.
Right. Oh, because of this.
Because of this, and the exemption was granted. Now, I will just take your lordship very quickly, as a reply, then obviously your lordship will consider. And when it just comes back to clause 23, yes, this is regulation 23,
Yes, please.
Has seen 23(1),
Yes.
governing body of every recognized stock exchange and recognized clearing corporation shall include shareholder directors, public interest directors, and managing directors. Now, kindly takes 4. 4 says the managing director shall be included in the category of shareholder director. So, if a managing director is there, it would necessarily include that it will be a shareholder director.
He would be treated as a shareholder.
Shareholder director. So, temporary shareholder director may not be required.
All right. Yes.
Now, now the exemption comes in. I'm pointing out why, The exemption says that there is no requirement of your appointment of a managing director anymore. Now, if your lordship kindly reads, what is this composition for? For the purpose of quorum also. I'll point out why. Kindly takes 10.
Yes. 10.
The requirement is that the number of public interest directors shall not be less than the number of shareholder directors to constitute the quorum for the meeting of the governing board. So this is only that the number of public interest is really more, has to be more. Now, if the shareholder director is 0 also, it will not affect the quorum.
Very well.
Now, it kindly sees 11. This is for the purpose of voting over resolution. Resolution shall be valid only when the number of public interest directors have cast their votes on such resolution is equal to or more. Again, if it's a consequence of 0, it is always the public interest directors whose decision will be final. Now, let us consider a situation, where there is a managing director and there are public interest directors. There is no dispute that there are public interest directors. Vis-a-vis that, let us consider there is no shareholder director. Hypothetically, let us consider, is the board available or not available? That is a question. In view of 4, it's a valid board. It's a valid board.
What is a valid board?
With the managing director and the public interest director only. It will be a valid board.
Yes.
Now, if an exemption is granted on the managing director, that is an exemption granted by the regulating authority. Considering that there are no shareholder directors in this company anymore.
It's the other way around, Mr. Rai. If there was no shareholding director, then the managing director would be treated as a shareholding director and he would comprise the quorum. But if there is no comprise the board, but if there is no if you have shareholding director, if there was an MD, he could double up as an MD and as a SD.
It is not the question of inclusion as to which category and why is that?
23(1) is specific.
May I just
Shall include.
include? It's
Now,
an inclusive.
one read with 4 might be construed to say that yes, if there is a managing director, he would double up as A and C, shareholder director and managing director. Understood. But if there is neither, then there is no shareholding director at all in the board. But you have shareholding directors.
I'm on the earlier step. Let us consider there is no shareholder director, but only a managing director and a public interest director.
Then managing director would be treated to be a shareholder director as well, and a managing director, and he would form this governing body.
That is it.
Yes, good. But if there is no managing director, but there are shareholder directors,
There are no shareholder directors. I'm going on that point.
in the company there are no
shareholder directors.
in the CSE there are no shareholder directors at all.
These shareholder directors, these shareholders have to make an application because these are members, individual members. These are all not in the nature of shares as such.
Share of a not like a share of a company.
That's what I've been told.
CSE, what is it? It's not a
company.
CSE then
shares are there, but the application has to come up from a shareholder to become a director.
But without shareholder directors, you cannot form a governing body.
Again, I am saying, the shareholder director, that is why 4 has been given.
4 has been given for some other purpose. Managing director shall be included in the category of shareholder directors. So managing director, if there is a managing director, the shareholder director requirement is fulfilled in a governing body. But if there is no managing director, then there is no shareholding director at all. This does not say that
this has been considered by the
still remains. For the purpose of 1, 4 says that managing director may be included in the category of shareholder director. So if there is a managing director, shall be included in the category of shareholder. Managing director would cover both. But if there is no managing director,
so that has been considered by the authority.
But there is nothing akin to 4 to say to dispense with the presence of shareholder directors altogether in 1.
But it wouldn't be. But that is what I'm saying.
It is not that public interest directors then would develop as shareholding directors. If it was provided that public interest directors cannot be.
The reason is absolutely separate.
Exactly. Therefore, without any shareholding director, without any shareholder director.
That is what I'm saying, the shareholder director was in the nature of the managing director.
No. Not the converse. A shareholding director is not a managing director. Managing director is a shareholding director.
Managing director was the shareholding director.
Managing director, Mr. Rai, is a different category. See, this is managing director, these are shareholding directors. 4 only says managing director will be constituted to be under this category, shareholding directors.
Yes.
Therefore, the governing body remains shareholding directors, public interest directors, and managing director. If managing director is included within category of shareholding directors, if the managing director was there and public interest directors were there, it would form a valid governing body because managing director would wear 2 hats, managing director and shareholding director. But if there is no managing director, neither is there any shareholding director, then 23 is not complied with. The 23(1) has to be complied with. If managing director falls under the shareholder director category, then 23(1) would be complied with even if there was no different shareholding director.
Granted by the SEBI authorities themselves.
SEBI authority does not alter 23(1).
SEBI considers that whether there is a managing director or not, and whether there is the
completely different. You are arguing. See, 23(1) says there has to be 3 categories: shareholder, public interest, and managing. 4 says managing shall be included within a shareholder. So therefore, if there is a managing director, we can consider him to be under both heads, managing and shareholder, and say that yes, no, then also 23(1) would be complied with, because then C is complied with, managing director is there, B is complied with public interest director is there, and A would also be complied with because managing director himself is a shareholding director.
That is what I'm saying.
But if there is neither A nor C, then there would be only B. Then it would not be covered.
But I'm saying that is the exemption granted by the SEBI authorities.
Not to 23(1). To appoint MD, it has been granted.
21
Very well.
covers-
If there was no managing director, then we could constitute 23(1) to exclude managing director by virtue of this SEBI regulation.
And it also would include, my lord, the effect on 23(4).
Does the SEBI notification say that you are exempted from appointing shareholder directors also?
It said you do not need to appoint a
Managing director only.
managing director is covered by 4, my lord, also. Categorization of the managing director is the shareholders director.
But it does not say that you need not appoint any shareholder director. It says you need not appoint any managing director who would come within the capacity of managing shareholder director. The two don't mean the same thing.
My lord, if your lordship, my lord, the exemption has been granted.
Suppose we are giving a very loose example. Suppose there is a regulation which says that a judge of the High Court and suppose a member of the bar have to comprise a committee mandatorily. Now, there one of the other provisions say and 3, a judge of the High Court, Chief Justice, as well as a member of the bar. Now, another portion of the regulation says Chief Justice comes under the category of judge. Then if the Chief Justice was there, then Chief Justice would cover both judge and Chief Justice, and member of the bar would be there. But suppose if the Chief Justice is exempted to be appointed, a High Court does not have a Chief Justice, then at least the other two had to be there, because it's by dint of that exemption, it's not possible, it's an impossibility, therefore we could exclude him. But even then a judge and any other judge and the member of the bar, they had to be there. You were saying no, only a member of the bar would do. It's like arguing that. Then some other judge ought to have been there.
I'm saying
because there is no exemption regarding appointment of shareholder director. Only regarding MD, who would be constituted to be.
My lord, my functions are regulated by the SEBI authorities.
SEBI authority never exempted you from appointing.
Till date, my lord, have not taken any steps saying that is not compliant.
Shareholder director.
The SEBI has not said so.
SEBI need not say so. The regulations say so.
The control is by SEBI.
SEBI has not taken any penal action against you. That's a different thing.
So
that does not absolve you from the requirement of 23(1).
It is considered. SEBI has considered the situation.
No.
SEBI knows my directors.
With due respect to you,
My
Mr.
board is functioning. My board is functioning. SEBI has never said that no. My lord, I have a regulating authority who regulates these functions. This is under the regulations. So SEBI is the regulating authority, my lord. And that is why your lordship will also find that how quorum and as well as the requirements of passing resolution has been placed also by the authorities. This was with regard to, my lord, the directorship, my lord. And secondly, my lord, obviously the question of directorship, my lord, which has been placed, my lord, what I have understood is they have only said in their pleadings that it is not in the proper manner, and the precise public interested directors have not objected to it. What there is nothing mentioned, but this is what primarily has been argued.
Public interest directors have
not objected to.
To what?
And I'll place the pleadings.
No, objected to what?
To this wrong.
Achha, they have not objected. Yes.
That is what they say.
So how does that benefit them?
I don't know. I'll just point out. I placed it. I'll just place it once more. It is in the volume 1, my lord.
Of the
page 16
of the G.
Of the GML.
Yes.
And just say the page 16, first paragraph. it was further under the last sentence, my lord.
Hmm.
It's further not pointed out that the board of respondent was not validly constituted and therefore were not in a position to pass the order. The public interest directors, which fully being aware of this infirmity, have consciously chosen to pass such an order.
Yes.
So this is their pleading. And I say, my lord, at every instance, my lord, it was the board which was giving them notice. They have never said the board is not there. They were aware of who are the board members.
Hmm.
They are a member of that.
They're member of what?
They're a member of the Calcutta Stock Exchange.
Yes.
My lord, this is a company. You are a member. The articles and the memorandum will govern. You knew about all these things. Now suddenly from nowhere you come and say, no, this is not functioning today. Your own board. Well, this is not in the nature of disciplinary proceeding. This is absolutely under the contractual obligations under the Companies Act.
Yes.
To come and say that I am suffering a mental agony, that is not the question. It's a question of a contract. And as I said, this is the first time they raised this question.
Hmm.
Now, the next point. Well, I found those letters, so I'll just give that in the notes, specifically by the board, saying that you have to. Obviously, the list of it is a part of your pleadings, his pleadings. I don't show his pleadings.
You'll give the page numbers.
Yes, I don't want to do that. And I placed it earlier, so I don't want to again.
No need not. Everything is.
Now, my lord, Mr. Mukherjee has placed certain judgments, my lord. My lord, I'll just place that. But before that, my lord, I had placed substantial amount of the order, which I don't think has been fully placed before your lordship. So I had placed substantial part of the order, my lord, on the last occasion. But whatever, it's in quite some time. Well, I can do two things. I can place it again, or I'll just make that categorical note as to where the dealings have been made of this natural justice. I'll just do that because I had already placed it. It's no use again because again I'll get the next chance by that time again. So that's why I'll place that. I had already placed that, so your lordship will understand from there why I say only two things. I'm just making my
make your submission.
Submission. From the order, your lordship will find three things. One is opportunity of hearing was given. They were all along aware as to what is the case being made out against them. Question of show cause is a very technical term. If there is anything which has been shown to my learned friend, making out the case made out against them, and they are in a position to answer, and they have answered, then it is not correct to say that there is no valid show cause. Next, my lord, is the endeavor which my learned friend has to overcome or has to put in is to show that the prejudice test. I've already said that today. The prejudice test, I believe, my lord, has not been overcome.
That comes as a sub argument of the first argument. Yes.
Because, my lord, they have said that they were aware of everything. I have this, I don't have this. They've said everything. Now, on a hearing which was sought to be given, even at the very end, just before my lord, just after the writ petition, my lord, then also they say, we are not going to come. The appeal is pending. So the hearing.
So they knew about whatever documents were asked for by them. They did not produce the documents, took various flimsy pretexts. Certain documents were produced, but they had been going on saying that the other documents they won't be giving to you for some reason or the other. Now you take under statutory compliance, you have taken certain steps against them.
That is
so this is not a disciplinary proceeding that you have to give a full-fledged show cause making your
A
allegations.
hearing note, I get a hearing notice.
You have given a hearing notice also, and you need not have given a full show cause notice comprising the charges or something like that,
Then
because these are under the regulations. You are entitled to take the steps if they don't.
those notices itself also.
You gave several opportunities to produce
As to
documents.
why I'm asking for it?
The
What
reasons were also given in
Yes,
it.
the khate, but where did it come from? It was from those notices. And therefore, I say, my lord, the technicalities which has been looked into by these authorities, my lord, are far complex. It's not just a tip of the iceberg that there's no show cause notice. It has not been properly given. You are not prevented from going and saying this before the tribunal. The committee. You have taken a risk, fair enough. But is that good enough? Because, well, we cannot stand with a microscope of every instance and say this is wrong, that is wrong. If you were in a position to say that, you should have gone and said that. Furthermore, my lord, what will be the consequence of withdrawal of the challenges made to the earlier notices? First, in this proceeding, I say, my lord, that in the event they have not been showing that also, that there is a leave under Order 23, Rule 1. In that event, they cannot take that cause of action. Anything after that, definitely. But not those which primarily would have involved the authority, the cause or the inquiry, everything. They have also gone in a suit. Admitted position, the disputed questions of fact. If one goes to a suit court, that itself is an admission. So today, my lord, suddenly we come up here because the writ petition was dismissed and I was directed to take steps and I took steps. It requires your lordship that your lordship will go into all these questions. But I'm not trying to shy away, but I feel this is a case where evidence may be necessary also. It is contemplated because an arbitration proceeding has also been, arbitration agreement has been also been executed in the parties. That is what I want. Nothing prevented them. Now, my lord kindly appreciates the case laws per se.
ওদের সাইটেশন গুলো আছে আর্টিকেল ওনারা যেগুলো দিচ্ছেন তলার গুলো এগুলো yes
And it only keeps note of one page. Well, I'll give it in writing, my lord. Page 58, I pointed out, my lord. That is the last letter of Calcutta Stock Exchange of 2nd March 2022. This is volume 1 of the application, my lord. Where, my lord, they have been called upon for a hearing also. Last. Now, my lord, the judgments which has been referred to by তো কিছু চেষ্টা করলাম তাও টাইম পেলাম বলুন স্যার কত কিছু চেষ্টা করলাম লোক থেকে মেরেও দিলাম তাও পেলাম না এই পাঁচখানা দেখিস 5 judgments. Just check it once. One will kindly see, মানে 2014-9 SCC, page 105. আছে তো?
this is the new judgment you are citing.
No, my learned friends, I'll cite there, I'll distinguish their judgments and then I'll cite my judgment.
2014
মানে this is Gorkha Security Services.
yes sorry I got it. Yes.
And at paragraph 21 and 22, I believe, is what has been referred to.
Yes.
And this was a case of blacklisting in a tender process. where the Supreme Court held that yes, you need to give a show cause notice. Because they wouldn't have been aware, because here everything is stated in the regulations as to what actions will be taken, that is there. But here, it's a government authority in blacklisting a tenderer. And kindly see para 21. The central issue, however, pertains to the requirements of stating the action which is proposed to be taken. The fundamental purpose behind the serving of show cause is to make the noticee understand the precise case set up against him, which he has to meet. This is what I am also referring to and relying upon. Once they have met whatever has been stated against them, they cannot turn back and say there is no show cause notice. This is a case of hyper technicality. This would require the statement of imputation dealing on the alleged breaches and defaults has committed so that he gets an opportunity to rebut the same. And that he has done.
You say the opportunity to produce the documents was sufficient and the reason was also indicated. So therefore they had knowledge. They were aware.
Knowledge. They also knew from where it was being stated that you have made this, why this is not a, why this is a negotiated deal, why this is a khadepate part. That isn't stated.
Okay.
Then 22. And at 22 says, if equally, just in the medium, placetam A, where it's written, however, equally important to mention as to what would be the consequence the noticee does not satisfactorily meet the grounds on which then action is proposed. They were always aware that it was a violation of the regulations of the settlement guarantee fund. And the settlement guarantee fund is also an agreement vis-a-vis him and my stock exchange. So, this I have submit, this may not be applicable in the context of this case, and whatever is there, they have been well aware and made well aware as what was the case made out against them. Then, kindly sees, just point. This is 2022 SCC Online Supreme Court 1217, This is Kavi Arora versus Securities Exchange Board of India.
Yes. To disclose the materials you rely on.
Yes. And 27, 34 and 51. 27, if you logic kindly comes. Oh, the first paragraph is very important,
Yes.
This was a case, where the petitioner approached under Article 226 for directions against the Security Exchange Board to furnish petitioner's document relied upon in a show cause notice. And the primary requirement was, there was redactation on that document which was supplied. That your lordship will find let's first come to para 27. Since submitted the documents read upon by the respondent SEBI, the show cause notice could not be denied to the petitioner. I do not, obviously, it was always supposed to be given. In support of the submission, it took to Takano versus SEBI. Fairness, documents to be produced. There's no dispute about these propositions. Then, 34. And 34, it's only set out Takano, but what I'm more interested in is 36.
Hmm.
In Takano, this court approved and followed the law laid down in Natwar Singh and reiterated that the adjudicating authority had the duty to disclose the material that had been relied upon during the stage of adjudication. It is also to the adjudicating authority cannot exercise unfettered discretion to redact documents necessary for the notice to defend this case. That was the basis on which this order was passed. Can you see the order, minute? Page 50, para 51. Para 51, minute. The High Court rightly did not interfere in the proceedings on stage of the show cause notice. The petition has apparently been permitted to inspect the opinion form. There is apparently no rule which requires SEBI to furnish the opinion under Rule 3 to notice in its entirety. Documents relied upon for the formation of opinion in Rule 3 are not required to be disclosed to the notice.
Here, what was their allegation to cite this judgment? What have you withheld?
Well, they are saying the
According to-
report.
Report of?
That internal report where
The
they have come to a conclusion. The private conclusion, if I may say so, Malad, against which we have given them, asked them for all these documents and also answers.
So, what is your answer to that? Why?
I've given documents. The documents, there are letters. Malad, that's why Malad, last year I also shown letters which specified what are the grounds and all particulars with regard to what we found from the report. Everything given.
In your written notes of arguments, say that and give the page number also. You have annexed to what?
I have not.
They have annexed to what? The GH. Achha.
I will give Malad in the opposition also. It is there. I will give it.
That some of the letters say that.
Show Malad.
Yes.
The report has been taken. But let me proceed. I just show you.
Where? You have given the report. You had given the.
No, report has not been given. I am saying whatever the report was against them has all been disclosed in a letter and given to them.
In the letter, the contents of the report basically
Yes.
were there.
Yes. অ্যাফিডেভিটটাতে আমি ওটাকে অ্যানেক্স করেছি এবং এখন করেছি এখন এটাও বলতে হবে
What?
And I've been grilled also from this side, Malad. Mr. Mukherjee is grilling, Malad.
No, I'm not grilling you.
I know, Malad.
Right now, I'm not grilling you.
Malad, yes, that's very helpful, Malad, if I can say that. But that is what I was saying. Malad, in jest, I was saying only. I was telling Mr. Mukherjee, sir, how much I tried from the morning, but nothing prevailed. And as a matter of fact, now there are 2 instances for the court to not proceed also. Still, I could not prevail. Now, when it kindly comes,
You'll never feel ready, Mr. Unless you are
not
compelled to
on
argue.
the
You'll never, no counsel ever feels ready. I'm fully ready to do the matter. Nobody, I never felt it throughout my
In
practice.
the morning when I came before your Lordship, I was ready to do the matter. I
But
only
then you
said-
became unready.
No, I only told your Lordship that I have another matter. Your Lordship already said, no, you can't say
That matter is gone now. Whatever happened.
All of them gone, no problem. I am not on a problem for that. But then when it fell from your Lordship, a few things, then I said, then it was obviously, Malad,
No, you are fair enough. I mean, you are doing it. Thank you.
because when
Court is actually indebted to you for that.
Time doesn't say this one, it's our duty, Malad.
No, because the other matters would fall then. Nobody else is here.
Malad, I only sought for, if I could, I tried my last.
These are broken benches. That's why, I mean, let us.
It's just that, Malad, your Lordship has been on this side. Your Lordship knows what we have. in
It's
our
my
hands.
difficulty. That is why I cannot take stranger. I know fully what is your difficulty.
Now, Malad, kindly
Yes.
please at page 174
Of
of GA1, volume 2. All transactions, that's point
Okay,
of this ordinance. I think your Lordship would have noted it also.
page 101. এটা Yes, 174.
All transactions specifically provided.
Oh, the specific violations have been.
Your lordship must have noted it, my lord.
Yes, yes, it's there. It's there.
And they've also dealt with it. Page 179.
The details also.
Yes. Well, that is why I said, my lord, the prejudice test.
All right.
Now, the next judgment, which my learned friends have relied upon, 2013 SCC online, SAT, page 67.
Hmm.
SPJ stockbroker.
Hmm.
Well, this was an appeal referred from an adjudication under the SEBI regulation. Pure disputed questions of fact, which were dealt with. Now, my lord, kindly comes to para 12 to 14.
Yes. What? Over. Adjourned.
No, it's a But as long as the responsibility is not on my shoulders, and I feel
It has been shifted.
shifted. Under 12, penalty under impugned order is imposed upon appellant solely on ground that almost all trades in shares of Adani, affectable appellant during investigation found to be synchronized, and those trades were with only one group. It is well established by various decisions by this tribunal that synchronized trade is per se not illegal. Synchronized transaction will be illegal if it is executed with a view to manipulate the market, is dubious in nature and executed with a view to avoid regulatory detection, does not involve change of beneficial ownership, or is executed to. But who's making this statement?
In their case, they say these are not satisfied. I mean, nothing of this sort happened.
But again, they have to go and say that. In the hearing, they have to make out this case.
No, rather, you had to make out a case. Mr. Mukherjee had said that you had to make out this case. And
No, I have to make out the case that it was the
illegal,
synchronized transaction.
manipulate.
And he has to make out the case that synchronized transaction is not illegal.
No, here it says per se it is not illegal. So your mere saying that it's a synchronized transaction is not sufficient. You have to show that synchronized transaction per se is not illegal. You say it's synchronized transaction. Per se it's not illegal.
It is illegal.
In addition, you have to show that's his contention. In addition, you have to show that it is executed with a view to manipulate, dubious.
It's in that letter, my lord.
That was the submission.
It is in that letter.
Those ingredients have not been proved.
Yes, then whose liability, whose burden? Then whose burden does it become?
If you have not proved that those were dubious and when
I have given that. I have proved. Now someone has to overcome it.
yes. So you say you have given this
I have given that. They
to
have
manipulate.
gone for the hearing.
Very good.
And my lord, see also, my lord, para 13 is also important. These things have already been recorded in our letters as well as the reasoned order. Particulars of groups with whom this has been formed, how it has been traded.
Yes.
178, 179, and all letters thereafter, my lord. If your lordship remembers, we're talking about a Piani also, my lord, if your lordship remembers.
Yes.
For other reasons, it came into my mind again, my lord. So, it was there. Then, my lord, 2005-4 SCC, page 4. KC Sharma versus Delhi Stock Exchange.
Yes.
This is para 5 and 13, my lord.
6 and 13 probably.
I was sorry, my lord, 6 and 13.
State. Writ is maintainable.
Maintainable.
You agree?
Well, this is in the case of a service law. An employee.
No, you don't say that writ is not maintainable on these
Yes,
grounds.
that-
But you say the application is beyond the scope of the writ itself.
Yes. And in this case, well, this is a case of a permanent employee.
So in terms of the division bench's liberty, they could have preferred a different writ, maybe.
They could have. That is what I've said from the very beginning.
Yes.
They could
You
have.
have. Yeah.
And my lord, here, para 13, if your lordship kindly sees why I am referring to this, my lord. 13 ko then. This is a case of amenable to the writ jurisdiction. Termination of services, public taxes of powers vested under para 4 of the letter of appointment. I do not disagree with that. But even in cases of state, writs are always maintainable, but the alternative remedy is never a bar, but your lordship has created that. That's a test for your lordship. It is my obligation to bring to your lordship's notice that whether your
The
lordship
alternate remedy in the sense of arbitration is.
arbitration, disputed questions of fact, not a mere case of
Plus this
jurisdiction.
yes.
That I can point it out to your lordship.
Yes,
I
yes,
cannot
definitely.
I cannot take a point that it is barred. I'm not saying that.
Not barred. Self-imposed restriction is the language used.
Yes. So therefore, I cannot say it is not under Article 12. But what I said before the lordship is whether the self-imposed limitation should apply in this case or not. Now, my lord kindly sees the next one is, my lord, reported in 2000, volume 4, Maharashtra Law Journal, Trilochana versus Stock Exchange of India. ठीक है बच्चे तो देखिए छोटे का
Yes, yes. It's with me.
कौन सा number? But paragraphs 8, 9, 21 and 22.
Yes, these were the ones cited.
And this is again on that same point of writ jurisdiction, my lord.
You have no quarrel with the proposition, but you say in your case,
Yes,
special points that arbitration clause and
definitely.
application instead of a writ.
Yes, that is what I want to say. Then, my lord, 2018 SCC Online Calcutta 2937,
Yes.
Surendralal Giridharlal Mehta. Para 17, 32, 33 and 36.
Yes.
My lord, this was a case of, my lord, of FERA violation, my lord.
32 and 33 I have taken note of.
32, 33.
Anyway, 17 and 36 may also be relevant.
And there is more of the case finding, my lord, the facts, my lord.
So this was first notice of hearing was issued almost 9 years after issuance of
Okay,
the
so the delay. This is on the point of delay, my lord.
delay. Primarily
Your lordship kindly comes.
delay plus copies. I have taken a note. Copies were not given or something.
Yes, my lord, show cause notice. There was a dispute about that.
Yes, yes,
My lord, kindly comes to 33.
yes.
It will be seen from the fact. Is your lordship there? 33.
I'm there. Yes.
Sorry. It will be seen from the facts noted above that the first notice of hearing was issued almost 9 years after issuance of the show cause notice. The petitioner contains, now see, 9 years after the issuance. Petitioner contains unless copies of the relevant documents relied upon by the authority were supplied to him, he would not be able to defend himself meaningfully at the adjudication proceeding. There is nothing on record to show that the authority supplied such copies to the petitioner. There is not even such an averment in the affidavit filed by the respondent in this proceeding. Respondent remained completely silent against the issuance of the notice of
So your
hearing.
defense will be apparently that all along the proceedings were going on. One.
Going on,
Secondly, previous
issue.
writs, previous writ petitions were dismissed.
issued by them. And when it kindly comes to 34,
Hmm.
I know I might be sounding a bit, inequitable, but Malad kindly sees 34. In view of the aforesaid submission and the considered opinion that the petitioner cannot be held responsible for the delay in the adjudication proceedings, it is indifference, disinterest, and lack of diligence on the part of the respondent that has caused the inordinate delay. The petitioner has spent the last 26 years with the adjudication proceeding hanging over his head like the proverbial Damocles sword. It's very likely to cause worry, anxiety, and unpeace of mind to the petitioner. And again, But here we are against a company. The member is a company. And Damocles' sword, that is something which they were well aware, and they had been filing cases on a repeated basis. That cannot be a ground that I cannot proceed with such a proceeding. And it cannot be the only ground, may I say this, as I said, though I was arguing then I said so, but then many cases will all go like that. If I take that point that they will be only on the ground of delay, a proceeding cannot continue any further.
But you reopen it after a long time. That was the.
Let us understand what is reopening.
After 2004, probably you came up in which year?
No, after that 2013,
2013, yes.
They had filed writ petitions and suit.
And writ petition was dismissed in 2013, withdrawn.
Then, there was.
After that, there was a continuum.
There were suits, may I just point out.
No, after that, probably you came up in 2022 or something.
No, after 25th September.
Occasionally, you wake up and send letters. That was the sort of thing alleged.
Then the question of fixed deposits were coming up. They had placed fixed deposits with us.
You have kept it as a Damocles' sword. In fact, I mean, whenever something happens, you feel like doing it, you shoot a letter. 2003 last letter, then 2013. This is the tenor of the.
Asking for the refund.
Oh, that was.
And I have said that, look.
So you had stopped the proceeding. Their allegation is whenever they ask for a refund, it as a backlash, you again reinitiate the investigation.
Different thing, because writ petition case is that I have stopped the proceedings on the ground that I have conceded.
That no dues.
That is what they.
And after that, when they come up with this claim of refund, then you again raise the bogey of.
2015 it was continued, not 2022. Not 2022.
When do they ask for the refund?
19 January 2016 is there.
So before that you had been proceeding. 2015 you had.
2013 it stopped. And then
No, they have painted a picture, Mr. Rai.
Yes.
Of what is the truth according to in their perception. 2013, up to that you had been carrying on with these letters and all. Then no dues was given. No dues was given when? 2013?
2007.
Oh, even after that letters were given. For which they came up with these writ petitions saying that after no dues you cannot do this.
Yes.
And those they withdrew.
Those they withdrew. Will also consider the quantum. It's not something which is not linked to something which this country has not seen as yet. It was specifically from that era that this has happened.
What is the quantum?
Quantum is the entire transaction that the SEBI had said somewhere around 2,000 crores. Here the quantum is somewhere 211 crores.
2.11.
2.11 crores against them. But this was a part of a huge scam which was coming out.
How many zeros?
I don't know.
Yes.
And this your lordship will agree with me. He is better off.
No, he may not know the number of zeros.
Zeros he won't know. Numbers he
not interested in the zeros.
He won't know the number in front. That he wouldn't know. So, these are the judgments. Now, I will be placing very few judgments.
One unreported. No, this was in Dalmia Security. This case itself. Why was this placed? A previous order by Justice Prakash Srivastava's bench.
That was the division.
That order. Yes, Mr. Mukherjee, I've got it. Meanwhile, 45 days that. No, this was preferred against this WPO. That division bench order.
My senior has shown some other judgment I missed.
Other judgment? I'll just check up. No, then I've also missed.
I don't know if your lordships have 2018, 13 Supreme Court cases, 7.
I'll just check up. 2014, 9 years, 2022, 2013, 2015. 2018 SCC online Cal was produced. Justice Arijit Banerjee.
That's
No other judgment is with me. No other judgment. These are the judgments which Mr. Rai has dealt with. These are the only judgments which are in my records.
sure they can have to be.
আমার কিন্তু নেই সেই জন্য বুঝতে পারছি না।
What are you dreaming?
At least it was not cited on which
My lord,
I were present.
my lord,
Some other day maybe.
ওরা নোট নেই বলছে আমি জানি না স্যার আমি ছিলাম না কিছুক্ষণের জন্য তাই বলুন
my,
wants to place I will not stand in.
no, my lord, because last I argued was December 23, my lord. That much. My lord,
But from the morning he has been telling me this.
I requested him, my lord, to please do it today and not ask for time.
No,
I
rightly,
requested
because
him.
yes.
এটা cited হয়েছিল
Mm,
আমার বইটা
not cited probably. Otherwise, it would be with me. Because his notes also do not contain it. Otherwise, it might have been that it was cited, no copy given to me. But apparently, they have also
I
taken.
apparently cited it from a book, my book, my lord. I got it last moment and maybe the,
Oh, that might explain why it is not with me. No copy
Yes,
is with
ma'am.
me. Maybe, but the notes also don't contain it.
আপনি বলবেন আমি আমি একটু বলবো। No? You will be doing those things.
দেখাচ্ছো তো?
No, nowhere it's. You can find it anywhere.
ভানুমতির জাজমেন্টের আগে সবই তো ভানুমতি। Kindly give me a moment, my lord. I
Yes,
don't
yes, absolutely.
have
Just check up.
my lord, I just
No, please check up. Yes, I'm also just checking up whether I took a note
তুমি
somewhere.
আজকে শেষ করে দিচ্ছ তাহলে আমি তোমায় জানিয়ে দেবো so that you can finish it up. I'll need to check my book which I cited. So, lordship's notes don't have it, my lord.
No, I did not. Any of these.
আজকে তো তিনটে অব্দি বেঞ্চ
Yes, 7 minutes, 6 minutes. left.
বেঞ্চ আছে তাহলে পরের দিন let us have the next Friday মানে
Yes, next Friday I may rise early because I have some. I mean,
whichever date মানে
we'll-
I will take maximum
I'll keep it the Friday after that.
I'll take maximum 15 minutes মানে
Kill 5 more minutes so that the appellate side matters are not taken by surprise. Yes.
I'll just check, my lord.
Yes, Mr.
my-
Because you check up on the next day. Just give him advance notice and cite it on the next day, and I'll hear his reply to that. You just go through that, Mr. Rai, once you get notice, and deal with that also. And I'll take it to be their citation on the last. You want to cite any judgment?
yes মানে that is
Ci-
why I'm trying to
You can start citing the
Yes,
first
ma'am.
one, no difficulty on.
The violation of natural justice. My lord, I will be placing judgments primarily, my lord, on two questions. One is disputed questions of fact, contractual dispute. And next, my lord, violation of natural justice, my lord, prejudice.
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 Mr. Rai, don't multiply too many judgments on the same point. Yes.
Three judgments have.
Fantastic. Yes.
That's what I intend to do, my lord.
Yes. Start citing today.
Yes,
One.
yes, my lord. এটা দেখো এটা ধর না প্রথমে 59 এসএসসি দেখো দিদি
কোনটা?
59 এসএসসি 433 দিচ্ছি স্যার দিচ্ছি মানে this is on disputed question of facts and contractual dispute.
Read court will not interfere.
Sorry, man.
Read court will not
Okay.
interfere.
This para 12, 14, 16, 20, 21.
Great.
12, 14, 16.
Proposition is well known and well settled.
That's why I only want to show one. Because well, obviously, but for the completeness, well, I need to show. That's why I show.
Definitely.
ABL এটা লেখা আছে ABL নিয়ে ইনক্লুড করা আছে 20 তে বলা আছে the instrument was state was placing a different construction clause of the contract.
Yes, a bill is there.
ABL is mentioned. যা আপনার কাছ থেকে সব শিখেছি ওই সময় সব লিখে দিচ্ছি নিজেদের চিন্তা নেই then my lord kindly takes my lord 2023 2 SCC 703
Have you got a copy?
Yes. 2023 703 Also 2023 SCC online Supreme Court 1223.
This is on the same point.
Yes, my lord, I just want to read, my lord.
Any para?
My lord, 23 and 30, my lord, 30. এটা নয় কি বলছো 23 2 SCC 703 তুমি কি দিয়ে দিচ্ছ এটা আজকে
Something else entirely.
I'm sorry, man. Let me come back.
Tender fundamental rights and other things. That's what it is. I have copyright over that scoring through.
ছেড়ে দেবো
No, no. Very well. Heard learned senior counsel appearing for the Calcutta Stock Exchange. So for further hearing, let the matter be listed on November 14, 2025. 14 November.
Very grateful.
Thank you. আজকের ভিডিও এখানেই রাখলাম, একসঙ্গেই রাখলাম। Appellate side.
Before your lordship takes up the appellate side.
No, I'll take mention. Oh, you are mentioning origin side. Yes.
The next item, lordship, I am the respondent in item 5, lordship. May I only pray that it is taken up on 14th instead of 7th?
Other side is here.
Yes, I'm here.
তাহলে এটা এই 5টা না এই ব্র্যাকেটে 14 কোন অর্ডার রেকর্ড করতে হবে না 14th মার্ক করে নিন 14th আসবে নেক্সট
I'm extremely obliged.
থ্যাংক ইউ
Lordship,
আচ্ছা অ্যাপেলেট সাইড এক সেকেন্ড জয়কুমারের সঙ্গে একবার অনিন্দিতাকেও ডেকে নিন দ্বিতীয় অনিন্দিতা
whereby Lordship needs to mention the item number 6. My lord,
ওয়েট জাস্টিস জয়কুমারের সঙ্গে কথা হয়েছে আমার জাস্টিস ভরদ্বাজের সঙ্গে কথা হয়েছে
to mention original side item number 6, my lord.
অরিজিনাল সাইড অলরেডি ইটস ওভার
My lord, we have received
no.
instruction not to proceed with the writ application, my lord.
should have told us when the officers were there court officer আছে এখন ওকে অফিসার 6টা কল করে না আদার সাইড ইজ দেয়ার 6টা একবার কল করে দিন
Not here.
হোয়াট ইজ দ্য ম্যাটার
My lord, this is a election, this is a fight in the committee.
Read
My-
petition.
Yes, my lord. The,
Watch, you don't want to proceed with the matter.
no, my lord.
Item 6 একটা order record করুন তো origin side item 6. Learned counsel for the petitioners submits on instructions that the petitioners do not want to proceed any further with the matter. Accordingly, WPO 1700
My lord.
1700 of 2023 is dismissed for non-prosecution without any order as to cost. Interim order, if any, stands vacated. Thank you. If you can, please inform your other side. Otherwise, they won't be knowing that this matter won't be happening.
My lord.
এবার appellate side এ কোনো mentioning আছে কিনা?
My lord, I am the petitioner.
Appellate side?
Yes, ma'am.
Done. জিজ্ঞেস কোনো mentioning আছে কিনা? Yes.
I am the petitioner. I have filed one can for stay in the ex parte proceeding in the trial court. Tomorrow is the trial court is going for ex parte proceeding.
Which item?
It is 17. Actually, it has not come in the
I'm
list.
sitting singly today. You may be mentioning a division bench matter.
No.
Single?
Single vote. It has not been, it is pending. I think,
Pending all matters are in my list. Appellate side.
yes, ma'am. It is showing here.
No. Is it assigned to me? These are only assigned matters.
No, it has assigned to your bench. Earlier it was in here, bench 6, I believe. Now it has come to your court, my lordship.
CO matters এ চলে গেছে. CO matters were assigned to me for 2 weeks before the vacation. And in the assignment order itself, also in the list, it was indicated that that assignment was up to the date immediately before the closing date.
Okay.
After that date, after vacation, those have all gone back to their original courts.
My apologies, ma'am.
Right?
Item number 1.
One, that matter for payment of 44 years. Lordship, kindly recall the order dated 23rd September 2025.
Yes.
Report is required to be circulated, my lord.
I've just got it today. Now.
And my lord, so far money is concerned, my lord, only 8,000 they have
No, your lordship,
paid so far.
kindly sees.
Possibly widow pension
No,
of the widow daughter.
no, what was, kindly sees page number 4 of the affidavit that I have submitted before your lordship.
Page 4, yes.
Yes. We have calculated the sanction order, kindly sees the dates also. In terms of the rule 16B, is 168B of the WBSR Part 1 and Finance Department Order number 3371F dated 25/3/78, sanction is hereby accorded to the payment of a sum of rupees 4752, only being cash equivalent to leave salary for rupees 240. The days utilized earned leave to late Sachipati Ghatak, ex-driver of Katwa SDH, Purva Bardhaman, who demised on this and this date as per calculation noted below. Any overdraw that is will be drawing and disbursing officer in respect. Then kindly sees the calculation is laid down. Basic pay, D pay, DA. What it comes to is 562. How we have calculated is equivalent to leave salary 594 into 240. The total amount is given. Now kindly turns over the page. The last paragraph also, if your lordship would like to see. Actually, the amount of leave salary was required to be disbursed to. We have taken so much of precautions also. To late Bhakti Rani Ghatak, but Bhakti Rani Ghatak, wife of late Sachipati Ghatak, demised on 7/12/2006 without receiving any family pension and other death benefits. In compliance of the order of the Honorable High Court in WPA number 218/7 of 2022, dated 21/8/2023, read with the order of the Honorable High Court at Calcutta in MAT number 488 of 2024, dated 12/6/2025, and read with order of the Honorable High Court in WPCRC number 34 of 2024 in 218/87 of 22, dated 3/9/27. This is the subject to pay LTA of pension to the legal heirs of late Sachipati and his wife, late Bhakti Rani Ghatak. Legal heirs, Srimati Aruna Mukherjee, that is widow daughter, and Sri Kalachand Ghatak, unmarried son, are eligible to draw amounts of death cum pensionary benefits late Bhakti Rani Ghatak at the rate mentioned above. Then after that, your lordship comes to page number 5. These are the bill details. employee number, bill, payment, head of account, and what is the sum that is to be disbursed, which I mentioned on the previous page 4. Now your lordship again comes to page number 6. Date of, I will not trouble your lordship to go through, yes. Date of entitlements, details of entitlements.
Right.
Insured amount, this much. Accumulated amount in saving fund number 1983. Scheme for the period, number 1978 to December 1988, 1981 for 38 months, along with interest at the rate of 6% per annum. That is also given. Less recovery of outstanding dues towards insurance fund and saving fund, that's nil. And again, it comes to this amount. So the late Sachipati Ghatak was a member of the group Insurance Cum Saving Scheme 1983.
So you've given the entire breakups.
Entire breakup.
And you say that they are entitled to have these amounts.
Amount and disbursal also on every page, the amount that we have fixed and we have decided the breakup. On the next page.
You have already made the disbursal.
Yes. Now that is for my learned friend to.
My lord, kindly see.
You have disbursed how? Bank transfer? How?
Yes, this is how we have disbursed. Bill details, Annexure 1, all bank transfers. Bill number and date.
Right.
4,752.
Yes.
Let's kindly see. My lord, the person, my lord, died in the year 1983. And my lord, they are claiming that he was not in service. Lordship was kind enough to direct them, my lord, to produce record. What record lying with us? We have
that was finally decided.
Lordship note. From for 44 years, my lord, the widow wife did not get any farthing from them. And thereafter, my lord, widow daughter not getting any farthing from them. Leave salary, gratuity, other things, everything's there. At the outset, they have calculated in such a fashion for a limited period. Lordship was kind enough in contempt jurisdiction once again direct them to calculate entire period, because my lord, the presumption is that he was in service. Now, my lord, today itself they are showing certain paper after fighting since my lord 2014, and my lord certain paper, my lord, totaling amount of rupees hardly, my lord, 30,000 to 35,000, possibly, my lord, if I am not wrong. Let me allow to check it and come back before this honorable court. Because, my lord, the state authorities is very reluctant, my lord, so far this case is concerned. Even it was upheld by the division.
That is universal for the state authorities.
Yes, my
lord. Not only Article 14 is not violated.
They are taken a
strong apathy is applicable to everybody.
But they are taken a strong exception.
The advocates for the state take the wrath of the court every time.
Strong exception, ambulance driver, because of have not white.
We have considered those things.
Lord, I'll come back, my lord.
Did not.
I'll come back, my lord, to show once again.
Strike the sentimental chord again. On that ground only relief was given. But please check up and come back.
Lords.
If there is any doubt or anything else you want to add, then you just mention it to your learned friend beforehand, so that she can also take instruction and come back. It will just curtail again. We take it up only on Fridays. Just indicate to her after checking that according to you, this has been omitted, so that she can also take instruction and come back and tell us. Affidavit of compliance filed today be kept on record. Proof of learned counsel appearing for the alleged contemnor submits that all dues in terms of the order of this court has been disbursed in favor of the petitioners. For some next para, learned counsel for the petitioners seeks some time to ascertain the veracity of such claim. Accordingly, let the matter stand adjourned till November 14, 2025. In the when the same be next listed under the same heading. In the event the appellants, petitioners have any dispute as to the disbursals or the quantum for which the petitioners are eligible in terms of this court's order, the appellants, the petitioner shall be at liberty to file an objection to the affidavit of compliance on the returnable date with an advance copy to the learned advocate for the alleged contemnors. But do that sometime in advance so that she'll at least know she can take instruction and
I'll grateful, your lordship.
Thank you so much.
Item number 2.
The affidavit filed today be kept on record. Affidavit of compliance kept on record. This is the second occasion when none appears for the parties at the time of call. Accordingly, SA 558 of 1965, along with Can 1 of 2003, within bracket old number Can 3823 of 2003, bracket closed, comma, which is treated to be on the days list, comma, are dismissed for default. Interim order, if any, stands vacated.
Item number 5.
T4 ফাইল এখনো আসেনি কেন? আপনি চাপ দিন, এই বেঞ্চটা কতদিন নেবে? এগুলোর জন্য শুধু বসতে হচ্ছে তো আমাকে। আইটেম 5 এটা। None appears for the petitioners at the time of call. None appears for the parties at the time of call. Full stop. As a last chance to the petitioners to move the matter, comma, the same is adjourned till November 14, 2025.
Item number 6.
Milord,
Yes, Mr.
here, Milord, I do have an application, Milord, Can 1 of 2025, where, Milord, I prayed for modification, certain modification of my Lord's order. Milord, that is, Milord, at page 18 of my Can.
এটা এগুলো ইয়ে কেন? ভলিউম 1 আলাদা রয়েছে, আবার সিপিএন এটা কি? এটাই তো ভলিউম 1 হওয়ার কথা। কন্ট্রিবিউশন একটা হচ্ছে, আবার ভলিউম 1 আলাদা কেন? এটা কি?
এইটা কেন তোমার?
না, আমার Can 1 of 2025, এটা সিওর কানেকশন আপনাদের দেয়া হয়েছিল আগে।
হয়েছিল।
হ্যাঁ হ্যাঁ, ওইটা সৌনক মন্ডল, দেখুন। হ্যাঁ হ্যাঁ হ্যাঁ।
হচ্ছে না।
এটা অ্যাপিয়ার করছে লিস্টে, কেন তুমি দেখেন?
একটাই
তলায় মনে হয় আগের দিন অর্ডার ছিল ক্যান উইল বি হার্ড ফার্স্ট।
লিস্টে আছে, দেখুন ওখানে।
ফাইলটা নিন না,
ক্যানটা লিস্টে আপনি একবার চেক করে নেন না, আছে কিনা ফাইলে।
ফাইলটা চেয়ে
That is your copy.
Mr.
That is
Ali
my copy,
do
my
not
lord.
have Milord
I
anything Milord to
I
say in this
hardly have anything to say.
Yes, that's
because they want a modification of an order. I believe that the Lordship has directed them that 25 lakhs be refunded.
But in a nutshell, Milord, if your Lordship looks at my can 1, I have annexed Milord the order, Milord, under
Yes.
modification.
আছে ক্যানটা আগের দিন অর্ডার হয়েছে তো নেই কেন? আগের দিন তো লিস্টে ছিল। যাবেটা কোথায়? পেপার ছাওয়া হয়ে যাবে এভাবে? এটা কি? সবকটা আলাদা করে দেখুন, তা নাহলে খুঁজে বার করুন এখন। আজকে প্রচুর কাজ আছে, রাত পর্যন্ত থাকতে হবে। যদি কোড চেঞ্জ হয় তাহলে অন্য কিছু থাকতে হবে। Which page?
Page 18 of my Lord's brief, Milord, can 1.
Yes.
My Lord would get Milord, my Lord's order starts. Not only, Milord, your Lordship, without disturbing any further, Milord, kindly
Why
takes
do
up
judges pass so long orders?
Milord, kindly takes up page 56. Page 56, yes. It starts, Milord, from page 18, but page 56. What happened, Milord? One of the devotees, Milord, come before your Lordship, Milord, before the tribunal first, that the arrangement that has been made, Milord, between the Mutwali and the promoter for development of a Milord,
Yes,
Waqf
yes,
property, that was under challenge. Milord, ultimately, in revisional jurisdiction, your Lordship, Milord, cancel, Milord, that agreement that
Yes,
was, Milord, entered into
Mr. Ali was for the petitioner.
Mr. Ali was for the
Yes,
petitioner.
yes, remember.
Kindly takes up page 56
You are
1.
there.
Apart from, Milord, cancellation of those agreement, Milord, your Lordship directed paragraph 109 that the board shall reverse the illegal process adopted pursuant to the scheme and shall refund the
Refund them.
amount of 25 lakhs. These 25 lakhs was not paid as a Milord, for the purpose
You are the
of
developer.
Yes. My case is that, Milord, in the modification, what I proposes before your Lordship, if your Lordship takes up, Milord, the agreement, it starts with the development agreement, page 67 of my Lord's brief. Page 65 to the Achha, Milord, if your Lordship prior to that kindly takes up page 65. Paragraph number 9. This is the resolution, Milord, of the Board of Waqf. Paragraph 9, kindly see. The developer shall be liable to pay monthly rates and taxes and all other cost and expenditure till the completion of construction of the building. There was a huge tax due. Milord, that's why, Milord, page 67, the agreement, it is an admitted position. Milord, the 67, it starts the agreement. Kindly takes up page 70, the first and whereas. So apart from 25 lakh, with regard to the arrears, from the date of execution of this development agreement, the board is acknowledging that apart from 25 lakhs, I have paid 22 lakh 7,216 by these account pay checks, Milord, to the KMC with receipts. So 25 lakh, which I have paid to them, thereafter 22 lakh 7,216 I have paid. And after that, Milord, from time to time with regard to the current, Milord, since my liability is till the completion of construction, I will pay entirely. That subsequent deposit, Milord, of tax, Milord, I have annexed starting from 106 onwards, but I will not trouble your Lordship. I have made a calculation sheet also with regard to the subsequent. If your Lordship takes up this, Milord, if your Lordship takes up, I have given, Milord, the first page of my calculation with regard to that 22 lakh 7,216, which is admitted, Milord. There is no dispute on that. Subsequently, page 2, your Lordship, from column number 2 onwards, I have paid this current also, and the total amount is coming 28 lakh 5,657, because 25 lakh they have already paid after the contempt application is being filed.
This plus 22 lakh? Or this is including the 22 lakh?
This includes 22 lakh.
22 lakh 700 to 16 is
Yes,
included
include
the total dues.
This total dues.
So these also are required to be refunded to you.
Yes, that much of modification, Lord, I am asking.
Yes, what do you say, Salah?
That already been taken resolution that if they come, that will be considered.
Go this evening.
Yes.
Very well, Milord. I was not.
This evening, go there and.
But your Lordship, kindly.
But because your lordship's order, they
Fair
have
enough. They're taking a fair stand.
109 of
I'll modify my order.
yes, yes, only to that extent. Paragraph 109 at page 56.
Learned counsel appearing for the petitioner in the modification application submits that in the order dated September 21, 2021, passed in CO 200 of 2021, comma, this court had, comma, inter alia, comma, set aside a judgment and decree dated November 19, 2020, passed by the Waqf Tribunal, West Bengal, in suit number 12 of 2015, comma, holding that the impugned resolution of the Board of Awqaf dated August 12, 2014, and the consequential acceptance of the scheme offered by the Mutawalli and resultant transfer deeds and development agreement, as well as other documents, were rendered void ab initio, comma, being patently dehors the law and the Waqf deeds -in question. Furthermore, comma, the Board of Awqaf was directed to immediately look into the alleged irregularities and illegalities committed by the Mutawalli and take appropriate steps in that regard. Next para. Further, comma, the court had directed that the board shall reverse the illegal process adopted pursuant to the scheme and shall refund the amount of rupees 25 lakh taken from the developer. Next para, learned counsel appearing for the petitioner submits, comma, by relying on the modification application and a schedule of payments filed in court today, that apart from the amount of 25 lakh, comma, an amount of rupees 28,05,657 oblique dash was expended by the developer for the project under the scheme, comma, which is also required to be refunded to the petitioner stroke developer pursuant to the order of this court. Next para, learned counsel appearing for the Board of Awqaf takes a fair stand and submits that a resolution to that effect has already been taken and the amount will be refunded to the modification applicant as soon as approached.
My lord, may I interrupt? I'm exact reading the resolution, that portion.
No, this is correct that you have.
That will be considered. My lord, one minute. Yes.
Will be refunded now. Will be considered.
Tax which the board should be held responsible to return, which needs to be considered for payment by the Mutawalli. However, if the said Hussein Abu Fayaz Rashid makes any prayer before the board, that may be considered later.
Will be considered by the board as and when approached by the developer. Next para. Mr. Mukherjee, we cannot expand the scope of the civil division application. We'll direct them to give a hearing to you and refund the amount whatever is liable. And I'll also give you leave if something else is left to recover that amount in due process.
Within a particular time, my lord, as your lordship may be.
Next para, in view of such stand taken by the board, comma, Can 1 of 2025 is disposed of by directing the Board of Awqaf to consider the claim of the petitioner, comma, as and when approached, comma, positively and upon giving opportunity of hearing to the modification applicant and further opportunity to the said applicant to produce necessary documents in support of his claim, comma, to decide the dues of the applicant and to refund the same, the entire exercise as indicated above, comma, including refund, shall be effected within 4 weeks from the date of such approach being made by the applicant. Next para, it is made clear that if after such adjudication, after such decision and refund, comma, if some other amount, some further amount is due to the applicant, comma, in the perception of the applicant, comma, from the board, comma, in lieu of the said scheme, comma, it will be open to the modification applicant to recover such amount in due process of law without being prejudiced in any manner by any of the observations made above.
I'm grateful.
No rest to question.
Taken on 27.
Whatever. I've directed you, they'll approach you within 4 weeks, you'll immediately decide and make the refund within 4 weeks. That's why I've given you 4 weeks time. Application. কোথায় ছিল? আলাদা কার সঙ্গে ছিল? তোমাদের দোষ। Grateful. This is a small courtroom. Difficulties, our files half are lying there, half are lying there. I'm reviewing them, but it's not their fault.
And looking at the determination your lordship is going
Yes,
to have even from Monday onwards.
for the first time in my judicial life, I've had a talk with the OSD of the Chief Justice saying that my officers won't be able to function if I have not added any matter last week. That this is the reason. This is the reason.
Heaviest bench.
Heaviest corpus. Anyway, thank you. Acha, regarding the contempt, it has been disposed.
No, the contempt, my lord.
What about the contempt? Now we
After
now
The resolution,
I'll pass penal orders after 4 weeks, so that will take effect.
No,
If I send
what has
somebody to
happened-
jail,
No,
it
what
will
has
be after
happened-
4 weeks, so that they can comply.
What has happened, my lord? I shall be candid, my lord. After
They have complied.
we filed the they have not complied. After we filed the contempt and after service of notice, Lordship, they have started the process, but the process will take time, my lord. Lordship, I am praying that this contempt
Probably there was
will
a
not.
change of guard, Mr. Ali. After that, things are happening.
Perhaps that is precisely the reason.
That is the underlying reason we cannot record it in any order of the court.
Lordship, that is why Lordship will
We'll give them some more time.
Lordship will
Dispose of the contempt.
No, this contempt may be moved out of the list. Lordship, if need be, Lordship, and if it is complied, I shall come and
So we'll
mention.
keep it on the list because Mr. Ali, otherwise this will be kept pending unnecessarily.
forever.
I'll keep it after 4 weeks or whatever period, Mr. Whatever you say.
It will take some time, my lord. It will take at least a month.
But
And in
according to you, what is it?
already pursuant to Lordship's order,
You have taken.
though it is belated still,
No, I understand. You have
the
been taking
process has
steps.
started.
What time should we give you? Tell me.
process has been started, 54 notice has been issued.
No.
And
Tell us
also
what would be a reasonable time. What was my direction?
direction
To reverse everything.
Yes.
Reverse everything
That is also
and
the
consider
concern
our
of
complaints
complaint.
about the illegalities which has been committed.
54 number of notices have been issued.
No. Section 54.
Section 50.
This is the resolution taken by the board.
So the Lordship will keep
When should I keep it? Tell me.
December, January.
Kindly come last.
No, when should I keep the matter in the list? Tell me. You.
6 weeks.
Very well. I'll keep it after 6 weeks. I'll keep this on record. The copy of a forwarding email as well as a resolution of the Board of Awqaf is handed over by Learned Counsel for the board, indicating that steps have already been initiated in terms of the order of this court and notices under section 54 of the
And also 64.
and notices under the appropriate provisions of law have already been issued to the concerned persons. Full stop, next para. Accordingly, on the prayer of the board, comma, let the matter stand adjourned and be listed next on December 12, 2025 for passing further orders. 12 December.
Grateful.
Thank you.
Item number 7.
Taken in favor of my learned friend, already taken.
No, he was telling that let the matter go out of the list. But that would keep the matter pending unnecessarily. If you comply in the meantime, I'll just record that and drop the count.
Comply.
By the order dated October 24, 2025, it was recorded that none had appeared for the parties at the time of call, and a last chance was given to the petitioners to move the contempt application. For sub next para, even today, comma, at the time of call, comma, none appears to move the matter. Accordingly, CPAN 742 of 2025 is dismissed for default without any orders to cost. Next.
Item number 8 to 14.
Din, file পরে ফাইলটা রেডি করুন। None appears for the parties at the time of call, full stop. It transpires that on September 18, 2025 and October 24, 2025, comma, the previous occasions when the matter was called on, comma, none appeared for the parties as well. full stop, by the order dated October 24, 2025, comma, a last chance was given to the appellants in all the matters to argue the appeals. Full stop, however, comma, since the appellant in the matters is not represented even today, comma, there is no recourse left to the court but to dismiss the matter for default. Full stop, accordingly, essay number পুরো list ধরে সবকটা are dismissed for default without any order as to cost. Interim order, if any, stands vacated. Next.
Item number 15.
পরে ফাইলটা দিতে উঠবেন যখন আগে ফাইলটা দিয়ে নেবেন তারপর পরটা নেবেন। This is the fourth occasion when none appears for the parties at the time of call. Full stop, by an order dated October 24, 2025, comma, a last chance was given to the appellants to argue the appeal. Full stop, even today, comma, none appears to move the appeal. Accordingly, SA 1006 of 1965 is dismissed for default without any order as to cost. Interim order, if any, stands vacated.
Item number 16.
Exactly same order. SA number 1031 of 1965. Last occasionটা ছিল October 24, 2025. ওটাই বোধহয় একই আছে রে। Next, ওই সব একই দিনে অর্ডার হয়েছিল।
Item number 17.
Same, exactly same. এই SA number 1107 of 1965. দিন দিন বলছি।
Item number 80.
Same.
Item number 19.
None appears for the parties at the time of call, which to be transpires that even on October 24, 2025, comma, the parties were not represented by counsel. Full stop. However, comma, as a last chance to the appellant to argue the appeal, the same is adjourned till November 14, 2025, when it will be next listed. 14th সব রাখলাম ইচ্ছে করে 7th যেতে খালি সব হয়ে গেছে।